Lordship, may I seek your Lordship indulgence?
Yes.
To mention item 20, personal appearance of the respondent 3 and 4 called for. Can it be taken up in 10:30, Lordship? After the
Tell it.
mention
Appearance on
hours?
behalf of the contempt norm, contempt
After the
petition.
mention hour is over?
Item 20.
Yes, your
20,
Lordship.
yes, ma'am.
Yes.
Can it be taken up as a first item, my lord?
But personal appearance is there.
Yes,
Your
yes.
Lordship, they are here.
Okay.
Officers of BTC.
It's okay.
May I please, your lordship?
Yes.
My lord, with the consent of the other side, my lord, I beg to mention item number 28, my lord.
28.
My lord, for
Why?
hearing, my lord, last item.
Why?
My lord, this matter may kindly be taken after
Why?
2 weeks, my lord. The day after tomorrow is Eid festival, my lord, and I will go home, my lord.
Huh?
I will go home, my lord.
Day after
Day
tomorrow?
after tomorrow Eid festival.
Not today.
But, far distance, my lord.
Where?
Zaleshwar, Golpara district.
Huh?
Zaleshwar, Golpara district.
How long it takes?
200 kilometers.
Are you inviting us?
200 kilometers, my lord.
We'll adjourn subject to the condition that you invite us.
Right, my lord.
On Eid.
Definitely, my lord. Definitely.
Okay. On the prayer of Mr.
AFNU Mullah.
AFNU Mullah. Learned counsel for the respondent.
Number 7.
Number 7, and prayer not been objected to by learned counsel for the petitioner, Mr. J. Abedin. Come on, let this matter be listed after 3 weeks.
Deeply obliged, madam. The concern of the counsel for the petition, my learned senior friend lordship. I would like to mention item number 17.
17.
17 lordship.
Ah,
Here we will file our affidavit lordship. Grant 2 weeks time lordship.
okay. On the prayer of Mr. P.N. Sharma, learned standing counsel, elementary education department, and the prayer not being objected to by learned counsel for the petitioner, Mr. J. Abedin. Come on, let this matter be listed after 2 weeks, so as to enable so as to enable the standing counsel to file affidavit in opposition.
May I please, your lordship?
Yes.
Lordship, I'm praying for listing of a matter for orders. Any date, lords, next week, lordship?
Next.
May I
Please.
visit? I beg to mention item number 11, my lord.
11.
Other side, my lord, I need some time to
My lord,
file our
5.
affidavit, my lord.
We have to file an affidavit.
Oh.
Maybe listed after 2 weeks, my lord.
Item 11.
Well, I don't know, 5.
Item 5.
5. Admission.
What is this?
That they were beer pass, but some certificates are to be enclosed with an affidavit regarding obtaining beer degree.
What is your grievance here?
That they obtained the beer degree prior to 2012. The government held that prior to 2012, those who obtained the beer degree, they will get the advance increment. But these petitioners, 3 petitioners, did not submit the beer degree. I asked them to bring the beer degree who passed the prior to 2012.
They have not done it, so
Now that I have to
no
annex.
more will procure.
That they have to, I have to annex it. Otherwise, the government will object. That
They
is
have
why,
given to you.
prior 2007, they have got the beer degree in 2007 and 2008 out of this petitioners, 3 number of petitioners. But at the time of filing, they did not bring those beer certificate. That is why, my lord, when inquiry is made, as per order of the High Court, and I directed them to bring the beer degree pass certificate immediately. And they will come from Kokraghar and then from Tinshika like that. So some 2 weeks time or 1 week time may be granted.
Okay. On the prayer of Mr. R.C. Saikia, learned senior counsel for the petitioner, submits that he may be granted some time to file additional affidavit.
File an affidavit.
Additional affidavit to bring on record certain documents which would be required for adjudication of the issue. Adjudication of the matter. This stuff.
Then, my lord, item number 18, my lord, review petition, the government has filed a review petition.
Submits, no? Submits. Prayer for time is granted, list the matter after 2 weeks.
After 2 weeks, man.
Yes.
Then item number 18, my lord, the
18.
government has filed a review petition.
Hmm.
But that I have to obtain instruction from my client,
Ha.
whether they have got the area salary or not.
Hmm.
One guitar and equalita.
Hmm.
Judgment was passed long back in 2015
Hmm.
by Honorable Justice Bhaipai.
Hmm.
But they filed a review petition after a lapse of 7 years.
Hmm.
But in the meantime, whether she is getting salary, I have to obtain instruction. 18 and 19, same item.
18, 19, huh?
Yes.
Mr. R.C. Saikia, London Senior Counsel, pressed for and is granted 3 weeks' time to obtain instruction. List after.
Obliged, Lordship. Obliged, Malik.
It is your lordship. Lordship, with the consent of the other side, I'd like to mention item number 32.
Hmm.
Lordship.
32.
Lord- Yes, your lordship.
Ah.
Lordship, my senior counsel is out of station for some personal inconvenience. Your lordship may grant me some time.
Okay. On the prayer of Mr.
Hey, Goswami and Prabhu.
He was, eh,
Hey, Goswami.
A. Goswami appearing on behalf of Mr. P. Mahanta, learned counsel for the respondent, and the prayer not being objected to by learned counsel for the petitioner. Anjedas. Gautam. Aram Deka, learned counsel for the petitioner. Let this matter be listed after 3 weeks.
Obliged.
Well, I beg to mention item number 11, my lord.
Hmm.
Here I need some time to file our affidavit, my lord.
On the prayer of Mr.
On behalf of petitioner.
PK Bora for the Elementary Education Department. my lord.
And the prayer not being objected to by MSK Devi, learned counsel for the petitioner. Let this matter be listed after 2 weeks, 3 weeks. 3 weeks.
My lord.
So as to enable the state,
Obliged.
the state to file.
Pass an order showing the name of the PA.
Hmm?
This is obliged.
Yes.
May it please all obliged.
May kindly be shown in the cause list, otherwise.
No, I will file, my lord. I will listen.
SC Elementary is there.
Well, I am also SC.
May it please the lordship. Lordship, I'm trying to list and matter for urgent listing probably anytime next week on Monday.
Why?
Your lordship, the petitioner has been denied of a lawful salary since March 2012. However,
No full salary.
yeah,
How you are appointed?
so there has been previous writ petitions and contempt cases filed in this honorable court. However, the impugned order of 3rd of January
Okay,
23.
next week.
Deeply
You
obliged.
just give that, get that. Not on, on a same day, huh?
May it be please your lordship.
Yes.
I beg to mention item number 2, lordship. Matter may be adjourned for the day only, lordship.
Item
number-
2, no,
Yes,
it's
sir.
wrongly listed, it's off listed. It's off listed already. Off listed already.
May I please, Lordship? Concern of the other side, Lordship, I beg to mention item number 26, Lordship. Can you adjourn for the day, Lordship?
Why?
My senior is out of station, Lordship.
That cannot be the ground. Anyway, only prayer of MS,
J. Gogoi, Lordship, on behalf of BP Bora.
learned counsel appearing on behalf of Mr. BP Bora, learned counsel for the petitioner. On the ground that Mr. Bora has some personal difficulty today, let this matter be listed after 3 weeks.
Lordship.
Hmm.
Deeply obliged.
May it please lordship.
Yes,
My lord, in item number 7, my lord, we have taken
7.
my lord. My lord, we have taken consent from the other side, my lord. I am mentioning it behalf of one Mr. D. Proceedings.
Hmm.
He has some personal difficulty today, my lord. Can it be listed after 2 weeks, my lord? If it is not inconvenient to this honorable
Okay.
court, my lord.
On the prayer of so and so, learned counsel for the petition.
Maybe.
Let, appearing on behalf of Mr. B.
B.
Prakash, learned counsel for the petitioner. Let this matter be listed after 3 weeks.
After 2 weeks.
2 weeks, huh?
Deeply obliged.
Please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 16, my lord.
Hmm.
My lord, today we are going to file a reply during the course of the day, my lord. Hence, the prayer is for adjournment.
On the
and
prayer of Mr.
MP Chaudhary, on
MP
behalf of
Chaudhary.
N Chaudhary, N Saikia, my lord.
MP Chaudhary, learned counsel appearing on behalf of MS in Saikia.
N Saikia.
Let this matter be listed after 2
Can it
weeks.
be on 31st?
So as to enable him to file, enable the petitioner to file affidavit in reply.
Yes, my lord.
2 weeks.
Full Lordship.
Hmm.
I am appearing for S1 number 3 and 4 Lordship.
Yeah,
Can
record
it
this.
be listed on 31st this month?
We'll just say 2 weeks.
Obligation.
Obligation.
Please, your lordship.
Hmm.
I beg to mention for listing of one urgent matter, your lordship.
What is the urgency?
The urgency is a suspension matter, your lordship. He is suspended from since 2000.
What offense you have committed?
Offense is a wife committed suicide.
Hmm.
Regarding that, FIR was lodged against me.
It's very
Thereafter,
serious.
I was suspended by the department, your lordship,
Very serious.
my lord. Madam, maybe list on next Tuesday, your lordship.
Hmm.
Or hearing day, your lordship.
You have
Tuesday.
you have abated.
My lord.
You have abated.
No, my lord. Actually, I have not committed that. Suicide.
Allegation is that there is an abatement to
Abatement.
suicide
Abatement of suicide. But
after 6 weeks.
no, my lord, because suspension matter,
Yes.
service matter, regarding service matter. your lordship.
You have abated
next
your wife to
Tuesday.
commit suicide.
But commit suicide, I am not involved. I am the block elementary education officer.
Next to next week.
My lord.
Next to next week.
On
Not next week because we have
next week,
allowed
Tuesday, your lordship.
we have allowed so many cases next week. After a week, after 10 days, next to next. After next week, you just give the date.
Next week on Tuesday, you will also kindly. That is very urgent, that is.
Huh?
That's why I meant, sorry.
That's why it's a matter of 1 week only.
Tuesday.
Next Tuesday.
Next Tuesday.
Next to next Tuesday.
Next Tuesday, my lord. Next Tuesday, kindly.
Next day, next Tuesday.
Next week, Tuesday.
Yes.
My lordship, for listing of a matter tomorrow, lordship, for
Where?
withdrawal, lordship.
Huh.
May please your lordships. In
Where is the
case-
violation?
Violation, my lord, lordship, can you peruse page 10? There is a long judgment, of course. This petitioner did not get the pensionary benefit, my lord.
Where is the direction?
Lordship, not for violation, but because after accepting notice, they have not entered appearance. There's immediately I tender my apology on behalf of my client. There's a lapse, some miscommunication after receipt of the notice. What happened? They have sent the, my lord.
Just.
The respondents are accordingly, page 16, last paragraph, directed to forthwith process of the case of the petitioner for giving pensionary benefit under the rule of 1969. Let such steps be taken and completed within a period of 6 months, my lord.
Who has to comply with the order? Three and-
They
three
have
and
not
four.
complied, my lord.
3 and 4.
Three,
I
not,
don't
yes,
think
3.
Who has to comply?
Lordship, pension and since we are from 6 schedule areas, as per constitutional 6 schedule, my lord, pension and public grievance is not a transfer subject to BTC. It's the government of Assam who is to comply with, my lord. But Lordship, regarding the
state-
other
who-
procedure we should follow, my lord,
Which is
the
the
processing the file and all.
Yes, who is what is the role of 3 and 4? Who are they?
And direct education BTC and
Inspector schools.
Huh.
Inspector of schools will forwarded the documents to the director. Then director forwarded to the government of Assam, my lord. That is the rule. And I have taken justice service. After getting the justice service, they did not appear. So that
Admittedly, my lord, what they have done,
Yes.
they have they have
That
proceeded,
is
lordship
the
forwarded
order
to
has
the
been
legal
passed by
cell.
the
There's a
court.
lapses on our, I admitted, my lord. We'll file a response today, my
Give
lord.
them.
We'll
Yes.
file a response today.
Have you
We have filed a wakalat
have you
nama.
received the notice?
Yes, I received a notice.
Then why you have not?
My lord,
Responded?
I have received the reports from the inspector of schools.
Hmm.
I have written to the BTC authority,
Hmm.
sir. And the BTC authority only I received yesterday, and then we have already.
What you have written?
Sir, on the
Lordship may kindly have a look, the communication. It is of yesterday only.
Then what, are they,
Lordship,
are they on the process of complying the order?
Lordship, Lordship may kindly have a look at the schedule, my lord, constitutional amendment.
That's okay.
Yes, my lord. Lordship. Lordship, today we are filing
It's
our
a contempt petition.
wakalatnama. Lordship, we are filing our wakalatnama only today, my lord.
Okay, let them
Yes,
respond.
my lord, yes,
Okay.
I have no objection.
MS K. Devi, Land Counsel for the petitioner. Mr. Your name, please.
JP Brahma, your lordship.
JP
Jagadish Prasad Brahma.
Jagdish Prasad Brahma.
Yes.
And Mr.
Herul Islam.
Herul Islam. No, Jagdish Prasad Brahma, Director of BTC. What is this? Director of what? The Director of Education. You have not properly addressed, I mean, put the designation.
Director
How
of-
can be this
Yes,
Director of
Lordship, I'm
BTC?
sorry. Education nahi likha. Director of Education.
Director of Education, BTC.
Who the-
BTC and Sri Jahrul Islam, Inspector of School, Baksa District Circle, Musalpur, have appeared in terms of the order dated 12/02/2026 and tendered the apology for not responding not responding to the notice despite duly receipt of the same. Notices, despite duly receipt of the same. List of MS BB Learned Senior Counsel appearing on behalf of the
That's for number 3 and 4.
this contender submits that due to miscommunication, the respondent, the above list contender could not appear, could not respond to the notices
Never apply. Kaise hoga?
and pressed for some time to file response as
Because
the
from someone.
you need not file power. You are you are senior lawyer. You need not. You have to file summary. The appropriate power would be filed on behalf of above two Alice contemners. List. Next para. Considering that considering the apology tendered by consider the apology tendered for not responding is accepted, Mr. Let the matter be listed after 2 weeks. In the meantime, this respondent 1 and 2, who is
1 and 2?
I am appearing for
Ah.
number 1 and
have you filed the response?
sometime maybe granted, my lord.
The,
They are becoming
I
very
would say-
elderly, my lord. The person did not get
in the
the
meantime,
pension.
let the Alice contemners to file
Finance also there.
their response, file their responses, list accordingly.
Holidays, my lord.
After, what is it? Then make it 3 weeks. 3 weeks. Okay.
One more aspect I should not submit because the counsel who appeared, whose name is shown in the writ petition, is no longer there. But he was not heard on the date of passing the order. Mr. S.R. Rao is no more. My lord, I should not make any comment against him.
We'll see.
S.R. Rao
The appearance.
Deeply obliged.
The
Personal appearance
personal
dispensed
appearance.
with.
That time, my lord, hearing
Accordingly
PTC affidavit was there.
last में apology वो नहीं covered, accepted only.
Their personal appearance be dispensed with, man.
It's a contempt proceedings. Director and the inspector is school. Mr. Brahma and Islam. Be careful next time.
Deeply obliged.
There's another, the personal appearance. I think they filed the affidavit. It was subject to, it's okay. Hmm. Yes,
It relates to the appointment of a assistant teacher of a upper primary school. Lordship. Petitioner was provisional list, his name was appeared for appointment, but in the final list, without any reason, they have dropped his name. Lordship. That's why.
have you participated in the selection
Yes,
process?
yes, Lordship.
What was the any interview, I mean, written examination?
Kindly, this is not a written examination. Lordship.
Yes, well, let us see the advertisement.
Advertisement is page number, page 30, Lordship. Sorry, Lordship, page 31. This is the advertisement.
What does it say?
It says that the Lordship
Contribute
in
to support student
page-
improve
page
according to
32.
elementary so
page 32, serial number 1, Lordship.
are
This
hereby
is the-
invited to official website so and so from eligible Indian citizens defined under who are qualified.
Category of post in next page, Lordship.
Just wait.
Page 32.
Very strange. On the basis of the allotment of marks, I mean, to the documents, no return, bye-bye, nothing.
My lord, here, my lord, this advertisement.
It's a fresh post.
My lord,
Is it a fresh post?
Fresh post, direct recruitment.
Direct recruitment.
Direct.
Only on the basis of marks
Marks.
to be awarded
That
on the
qualification.
documents. No return, no.
On the basis
Bye
of
bye.
that qualification certificate, Lordship.
It's all right.
my lord, this advertisement is of 2023, my lord. Already appointed all the candidates who have selected.
Lordship, kindly see page 48.
Where
His
is the
name-
select list?
Page,
Kindly
page
see page 51.
page 43 is the list, Lordship, provisional list.
50, 43?
43 is the provisional list. Where
Where your name appear?
my name, page 48, serial number 15, Lordship. Page 48, page number 48, serial 15, Lordship. Serial 15, page number 48. This is my name, Lordship.
Yeah. 15,
15, Lordship. This is
Shamim Ahmed.
Sai Mohammed, Lordship. He is in the right remarks, Lordship. Kindly see NIOS withheld. This is his status, Lordship. Thereafter, Lordship, by next page 49, Lordship, annexure 11, asking by the Director of Elementary Education, those candidate who have 18-month diploma in elementary education DLED from NIOS and in continuation to this office advertisement so and so.
Then you have submitted.
I have submitted.
Where it is?
Lordship,
Where it is?
submission is in the online system in the office, Lordship. I have submitted. This is record is available with them, Lordship, whether I have submitted or not. And page 51, this is the final notice where my name has not been found, Lordship. That's why I am prepared this writ petition, Lordship. On last occasion, this honorable court, after hearing this case, Lordship, asking the respondent authority to obtain whether any post is
But
lying
this
vacant. or-
advertisement, there is no vacancy. My lord, vacancy will be arise, my lord. He can participate in future. Whether
In
advertisement
future,
we should.
Lordship, I will become overage, Lordship. I have already, my name has been appeared in the merit list, Lordship.
But already all the candidates, selected candidates already been appointed, my lord. Kindly.
No,
see
no,
the-
you have
I
to
am
find
also
out how he has not been appointed when
Appointed.
his name is in the merit list.
Provisional list
Merit list.
Provisional list and
Provisional
then
list
it was withheld because of NIOS.
certificate,
Now, according to you, and you have issued a notice to submit.
submit.
And according to him, he has already submitted.
Sir.
Where is the consideration then?
That instruction I don't have right now.
Last occasion, this instruction was called for, Lord.
No, last occasion only whether
Any post is lying vacant or not.
up to as to whether any post is lying vacant or
Vacant
not.
or not.
See, my lord.
Huh?
This advertisement which he has channeled, but advertisement of 2023, my lord, there is no vacancy, my lord.
Against.
Vacancy
in
is there, my lord.
Lordship, in the provisional list, my name is appeared against the vacancy list, Lordship.
Well, issue notice, let them
Notice me.
file the affidavit. Heard, Mr.
ABT Hawk.
ABT Hawk, learned counsel for the petitioner. It is the case of the petitioner that pursuant to the advertisement dated 26/12/2023, he had applied for the post of assistant teacher in upper primary school list of the name of the petitioner was found placed in the provisional list for the district of,
Korimganj.
huh?
Sri Bhumi.
Sri-
Sri Bhumi.
Sri Bhumi.
Korimganj.
At serial number 5, with a remarks that the same it withheld for NOIS.
NIOS certificate.
Withheld, where is same is withheld for?
Page 48. Lord.
No, with the remarks that NIOS withheld. Hmm. Thereafter, list of. Thereafter, by notice dated 25/09/2025, the respondent authorities have directed all the candidates who have submitted their documents of diploma in elementary education, from NIOS to submit the UDISC code as well as the name of the working school. Accordingly, the petitioner submitted his UDISC code and the name of the working school on 10/08/2017. List of the petitioner also submitted the required information is directed by the respondent authority by notice dated 11/10/2025. List of however, the in the final list and in the final result of the assistant teachers of upper primary schools of Sribhumi district, that is 07/11/2025. The name of the petitioner. No, the petitioner was not found placed. No, name of the petitioner was omitted. This stuff. The Mr. It is submitted by the learned counsel for the petitioner that since the petitioner is eligible in all respect to be appointed as assistant teacher
Teacher upper
of
primary.
upper primary school and whose name was found place in the was found place who was provisionally selected with a remark of NOS being withheld and having been and subsequently the petitioner having been submitted all the required documents along with and the UDISC code in terms of the notices issued by the respondent authorities, non-selection of the petitioner is illegal. Huh? This stuff. This court on 19/12/2025 directed the standing council to obtain instruction as to whether any post is lying vacant or not. Mr. DP Bora, learned standing council submits that all the posts have all been filled up. Or have already been submits that all the posts have already been filled up and there's no vacancy. There's no vacancy. Huh? List of
Purpose of the advertisement.
next para. Having considered the submissions of learned counsel for the petitioner, I deem it appropriate to issue notice. I deem it appropriate to issue notice. Huh? Accordingly, notice be issued. Let the notice be issued returnable by return within 4 weeks. Huh? Since Mr. PK Bora, learned standing council, elementary education department, enters appearance. Who else are appearing? Why Union of India?
Lordship, they have issued the NIOS certificate, that's why, Lordship.
Why Union of India is required?
NIOS certificate issued by them, that's why I have implemented them as a party respondent.
Okay, no formal notice need be served in respect of
Respondent
respondent
number
1
5
and
is
2.
required.
However, extra copies be shown, sir. Petitioners to take steps for service of notice upon respondent 3, 4, and 5.
5 is important party, Lordship. Necessary party.
Whatever. Within 3 days, 3 working days. Huh?
Lordship, pendency of this petition shall not be a bar to appoint the petitioner.
We don't know. If there is no post, how can we do it?
If vacancy arise, Lordship.
Well, we have to
If
party-
No, that
vacancy arise,
cannot be.
Lordship.
I find it very strange. You are issuing an advertisement and the appointment is based on the awarding of the marks. Why not written exams?
Written exam is taken in the TET exam, Lordship. TET is the main written
There are
exam.
millions. thousands in the queue to compete.
This is
Anyway.
on the basis of obligation.
Obligation.
In this case, my lord, we have sent our affidavit for vetting.
2017 matter.
Because I have not received the appointment orders and the joining letters.
Of
We have-
what?
This petitioners, my lord,
Ah,
they have accommodated as tutors, my lord.
hmm.
They have refused to
Okay,
claim their.
Mr.
VK Boro, my lord.
Learned counsel for the petition. On the prayer of Mr. PK Bora, learned standing counsel, further 2 weeks' time is granted to file affidavit. The time granted today shall be a last chance, considering that the matter is pending since 2017.
My pleasure, Lordship. My lord, we have challenged the impugned order, that is page 33.
Amalgamation,
Yes. Page
amalgamation,
Yes,
or what do you call it?
yes, amalgamation of ME school with ME madrasa with high school. Page 33, kindly see.
I've seen it. Yes,
So name of the schools, Kaki Solsoli High School.
madrasa.
And it is high school.
Name of
And
it,
the name of the
Kaki
amalgamated school is
Sanchali
Kaki Solsoli ME madrasa.
High School. Amalgamated is, your school has been merged.
Yes.
Ah.
Now our submission is this.
What happened now? It's up to
It has been done.
2018, Lordship.
18.
From then stay.
What is the status now? Already amalgamated.
No, it is not. It is amalgamated, but it has
Right,
been
so-
state.
Huh?
State.
They are enjoying stay order, Lordship, since.
Stay order is there.
Okay. Then,
Now, Lordship.
then it's not functioning. It is, the school is running separately.
Separately,
They stay.
and not- they are
No, I just wanted to know whether the school at present
Yes.
is running separately
Separate.
in view of the stay.
Yes.
Okay, then
Now,
what
kindly
is your
see my-
grant? Why it should not be amalgamated?
Yes, that I am satisfying your Lordship. Kindly
Ah.
see page 20.
Page 20.
Yes.
Yes.
The department is receiving various proposals for amalgamation of different categories of schools located in the same campus.
Ketra scheme.
Same campus which are still pending due to absence of clear policy in the state. Now, it is decided that if the schools are situated in the same
Come
campus,
to
that may be amalgamated.
para 3.
Now,
Close 3. 1. Yes.
now kindly see page 24.
Page 21, yes.
24.
Come to page 21 first.
Not 21.
All the schools situated in the same campus will be merged with the highest schools.
Yes,
It's not in the same campus.
same campus.
Same campus. Is it in the same campus?
Same campus.
Then,
Now kindly see page 24.
ha,
Para 10.
ha.
If a ME school has 4 enrollment,
Para 10?
para 10, page 24.
It is subclause, Lordship.
It is part of the said memorandum.
Subclause of para 3,
Yes.
clause 3, yes.
Yes.
If ME school has poor enrollment so and so in this sense, then.
Less than 15 student
Yes.
in each class, then the ME school may be merged with the nearby high school. If
Yes.
the ME school has 4 enrollment, that is 15 per class. Now kindly say our school, what does our school possess? Kindly say now page 16. 1-6. Our school, we have given 3 years attendance roll of the students of the school, page 16.
Yours is ME school.
Yes, ME Madrasa.
Yes.
Now in 2015, our school had total class 6 114 students,
114
14.
at the time of amalgamation,
It is only in one class.
total
Total 316
at the time of amalgamation.
in 2015. In
No,
the
I'm
year,
asking at the time of amalgamation.
in the academic year 2015,
Sir, I'm asking, it was amalgamated in 2018.
yes.
What is the strength of students?
Yes, up to 2017, we have given the enrollment of the
Come to
students.
that, why we're going back to 15? Come to 17 or 18.
Yes, 17, 369.
Yes.
And 2016, 2 to 3,
Huh?
223.
Huh?
323
When?
in 2016.
It's okay. We'll just go by the last preceded year.
The last show,
Preceding year, we'll just see. 300, yes.
369.
69, yes.
369.
So
Now, as per their own wish memorandum, our school, though situated within the same campus, it cannot be amalgamated because our school has many times more students than required, number one. Secondly, our school has got all infrastructures. And school's result is also
you tell us. You tell us.
So
How do you reconcile with clause 3, 1 and 10?
one
1 says same campus.
same campus.
10 says if it is less than 15 students.
Yes.
How you reconcile?
The reconcile is that, my lord. Only in
There is no contradictory.
My lord.
There is no contradictory.
Contradictory, there is no contradiction as I understand. If
Then
the schools are situated and if the schools have poor students, poor number of students that is less than 15 in each class, then that para 1 will come into force.
suppose if it's not in the school is not in the same campus,
School is same
having
campus,
less than 10 students, I mean 15 students.
then it will be amalgamated.
So what is the, I mean, what is the requirement of providing in clause, subclause 1? The school is in the same campus and you have a subclause 10.
No, it is
How you reconcile it?
reconciliation.
Because it has to be read harmoniously.
Harmonious means that as the words appear, that is the harmonious interpretation.
What do you mean by that?
So here the word.
These two requirements of subclause 1 and 10 has to be read harmoniously.
Yes.
Then
if harmoniously, then first thing, one campus, same campus.
Second thing,
That is there. But if in the same campus, but number of students are poor, then it will be amalgamated.
otherwise there will be no.
Otherwise, what was the necessity to insert this clause 10?
You read the again you are supposed to read that, right? You read this clause 1 again.
Yes, the department is receiving various proposals for amalgamation of different categories of schools located in the same campus, which are still pending due to absence of clear policy in this regard. It has been found that there are many common campuses where different categories of school, higher secondary school, high school, ME school, and even LP schools also exist in the same campus. Instead of location of the institution in the same campus or in the nearby place, these schools are run individually with separate class routine and other individual academic functioning. In such system, the services of teachers of one school are not shared for the student of another school even in need. As a result, the shortage of teacher of one school is not addressed by the teacher of other school. On the other hand, if private school, the schools are mostly composite school having classes right from LKG, KG to 12 standard, which facilitate economic in administrative with optimizing utilization of services of employees and also provides the platform for linkage of education. Moreover, consequent upon provincialization of schools under the ambit of the Assam Educational Institution Provincialization Act 2011, some schools having very few enrollments have been taken over. These schools having low enrollment require merger with another schools, which may also facilitate saving in administrative costs. So it is only indication is also there. Some schools having very few enrollments have been taken over. These schools having low enrollment require merger with another schools, which may also facilitate saving in administrative cost, etc. So, my lord, it is not indirectly, directly it is saying that the poor enrollments, if there are in that school, so that should be amalgamated. But we have very rich enrollments in our school. So this one, first part is saying some conditions precedent. And now the second part is saying that if there are poor students, then only it will come into force. And more specifically in clause 10, it is more specifically mentioned if the school has less than 15 students.
Read 9 also.
And over and above, my lord, there is
Read
another
9
clause.
also.
There is another clause. Kindly see page
Read
20
9, subclause 9 also.
Clause 9.
In the even high school junior differential also.
9, if two or more high schools are located within the radius of 2 kilometers, so it is not our case. Our case is ME Madrasa merged with a high school, though we have better infrastructure, better number of students, more number of students. And there is another clause in the said memorandum. Kindly see page 26, para 7.
You read 11 also. If a ME school has poor enrollment, less than 15 students in each class, then the ME school will be merged with the nearby high school.
Yes.
It doesn't talk about the campus, same campus.
Yes. There is no
And if
school.
2 or more UPs,
Our only
ME
submission
schools
is
are
this.
located within radius of 1 kilometer,
Our only
then this ME school may be merged provided the number of students do not exceed 40. See, there are two contingencies, two requirements. If as per subclause 1, if the school, ME school is situated in the same campus with the high school or higher secondary school, it will be merged. Other requirement is if the ME school having less enrollment of less than 15 students, that will be merged with the nearby school.
Yes.
One is same campus, it will be merged. Other one is the school having a less number of, 15, less than 15 students will be merged with nearby school.
Nearby high school.
The nearby and the same campus, two requirements.
Yes.
If it is less than,
Even
it should be nearby.
Yes.
But if it is same campus, it will merge, irrespective of whether the less students or large students. Less or more. Even if 365, if it is same campus, it can be merged under subclause 1. If the school situates, is in a separately situates, having a less number of, having less than 15 numbers of students, then it can be merged with nearby school.
There is no dispute. Man.
Therefore, since your school is within the same campus, it can be merged irrespective of enrollment of students.
No,
that is my view. Then next, which clause you are saying?
Point 7, there is a provision from filing appeal, Lordship.
That's okay, we'll not go into.
So filing, they have paper
Yes.
honorable court.
Where is this? Page 26 you are reading?
Page 26, para 7, bottom, kindly see. Here, a clause has been, a provision has been laid down, that director concerned will issue necessary order for amalgamation for any disputes arising out of the order, the aggrieved institution public may prefer appeal before the government in the secondary or elementary department as the case may be.
So what do you want to say?
So, no, there is a alternative redressal forum. For that, my lord, we have filed already a representation that lordship may kindly see page 35.
Yes.
Page 35, our representation. But thing is this, that representation has not yet been disposed of by the authority. So we have been compelled to come to the Honorable High Court.
It was filed before the BO in a block level loss, not before the director lawsuit. Lawsuit can see the address lawsuit to the
Director counsel is necessary order for amalgam. For any disputes arising out of order, the aggrieved director has issued the order.
yes, it was filed
They prefer appeal before the government.
They have filed it before the BO. Block 11 edition of the lawsuit.
So we'll decide. Either you file an appeal before the government or we'll decide the matter on its own merit.
And as for the 2021 notification, it is before the government.
Huh?
As for the 2021 notification, it is before the government lawsuit.
Yes, that is true. It is filed before the
It is also here. Also.
It is filed.
Prefer appeal before the government.
Yes.
Yes, no, that is,
And
he
he
has
has
the
filed
representation.
yes.
I am admitting, because I cannot go beyond record. What my thinking is this, address should have been made to the government of Assam in education.
Where is your appeal, whatever?
Yes, my appeal
Representation?
is page 35.
Page 35.
Yes.
Block development officer, he is not a government.
He is not the authority.
He is the lowest
But
rank officer.
I admit that, but it is filed by the teacher. So I have annexed that. I cannot make out a new thing,
Yes,
what they did not do.
very
But-
fair.
But what they understood at that time, accordingly they filed that it will go automatically through DO, then director, then government. Now, lordship, that we may be given that option to file the representation before the appropriate authority. And till then, the status quo as on today may be maintained.
For a lot, 6 years, they are enjoying the status quo.
So
lawsuit.
what?
The
What is
school
the
are
harm?
suffering ultimately, that amalgamation is for the
Suppose-
betterment of the student lawsuit.
Suppose I am
Here the
entering
SMC
10 years or
teachers are
20 years,
agreed.
what is their harm?
Not the students are agreed.
Either you withdraw and we'll give you a liberty to file appeal in terms of clause 7, or will, since I have heard you, I'll decide on its own merit.
But merit is in our favor, madam, because pros 10 is very much clear.
Yes, I have heard you.
However, lordship, if your
will
lordship's proposal that stand by, lord, I have to receive.
No. Because I have heard you, I have given you at least 20 minutes. 20 minutes is a big, I mean, it's a huge time for such a case.
Let it be a two.
Choice is yours.
Okay, after half an hour, let me take instruction some, because I have no such
No,
instruction.
you have been duly authorized. You have filed the power with conscience and knowledge, with your vast experience of knowledge. So we'll decide, and you have, I have heard you.
Even then half an hour,
Hopefully, patiently.
half an hour can you give?
Because I know that what is your case, because tomorrow you may say that I have not been heard.
No, I never. It is hard how we can tell a lie before the honorable court.
Hopefully, I heard you patiently.
Yes, sir, you have heard. You have
In
heard.
fact, it was not required. You could
but-
have finished it within 5 minutes.
What is my lordship's view? I am not with that. My view is that when there is this clear-cut language, harmonious interpretation should be there, and interpretation should not be like that, which will ultimately frustrate the cause of justice. So there are Supreme Court judgment also. However, give me kindly half an hour and let me take an instruction. Particularly because this is a major point.
I may change my mind again after half an hour.
I think that will not improve this situation.
Half an
You have
hour.
not filed affidavit.
No, lawsuit. We have not.
Affidavit is not required.
Not required lawsuit.
Nothing, I'll not hear you even for a second now, after half an hour. You just take instruction,
No,
whether you would like
sir,
to
regarding
withdraw the petition at the liberty to file appeal,
Yeah.
or if not, I'll
That
say
I will say, that I will convey after half an hour.
after some time,
Yes.
10 minutes, after 10 minutes.
May I please, Your Lordship?
Yes.
This matter relates to provincialization of service of the petitioner, my lord.
Lord,
Here,
last order may kindly be seen, my lord.
Yes.
I said,
You koriban nahi liya hai.
good.
The thing is that, my lord,
For the respondent number 7,
yes,
submits in terms of last court's order, he has obtained instruct which is to be the effect the respondent has passed the higher secondary secondary on and the person. Why?
that with 49% whether I may be allowed to file additional affidavit in this regard or without filing the affidavit or record.
What is your case?
No, my lord,
Provincialization, my
my lord, Your Lordship, kindly see the second order of this honorable court, 8th March of 2021. This is my
8th March of 2021.
21. My lord, this is my whole crux of the case, my lord. Your Lordship, go through it, man, then I will.
In the incident, respondent is being processed for being promotional against the post of science teacher.
My lord,
Kochua.
my lord.
Respondent does not meet all the requirements of the applicant. Section 212 defines. Yes. Whether the affidavit has been filed or not.
My lord, affidavit has been filed, my lord.
Saying
By
what?
the direct. Nothing, my lord, only they admitted the fact that there is no seniority or preferential. At the time of the provincialization, my lord, qualification is to be required, my lord, as per.
So according to you,
I am a qualified.
seniority is not required.
My lord, not.
Only the requirement is the eligible quality.
My lord.
Eligibility.
Eligibility. As
Suppose
per-
if the two teachers or whatever,
My lord.
I mean, having the same eligibility qualification, what is the mode of recommendation or selection?
My lord, in that case, my lord, if had there been a censo, my lord, then seniority may. The question. My lord, at the time of appointment, my lord, he is not a qualified. Even the my lord, NCERT guideline, my lord, act, my lord, if your lordship kindly, National Council for Education Teachers Notification Act, my lord. My lord, I am reading just now.
Why he is not eligible, qualified?
He is underqualified. He is higher secondary science.
Huh?
Higher secondary science.
What is the requirement?
Requirement is as per Act, my lord, BHC with BLL. DLL, diploma in teaching.
Where it is?
My lord, it is there.
there is professional qualification.
Huh?
Professional qualification, both educational as well as professional.
Like B.Ed, my lord, here is primary, so upper primary, so it is DLED.
When the
DLED. Diploma in elementary education. Elementary education. Then
Now, if your lordship kindly see.
senior secondary 50%.
Last order have your lordship seen, but I have been allowed to acquire whether my candidature has acquired qualification or not. I have been directed by the owner to get the instruction, and I have received the instruction. Whether that instruction may I file with an affidavit or just document?
Has acquired the graduation degree in science after his permission as tutor.
After tutor,
I have been, my service has been promised as a tutor. There is a provision as a tutor within the 5 years he has to acquire the qualification.
Ha.
So that qualification, what I have acquired, whether I shall I file an additional affidavit for
No,
that
no, you
to
have,
bring the record.
you have acquired.
Yes, I have acquired.
Within 5 years.
I have within 5 I have acquired.
Graduation degree.
Not graduation. Graduation is not necessary.
Ha.
The percentage of mark is necessary.
No,
Huh?
no, madam. My lord,
Percentage of mark is necessary.
See, you,
kindly
you
see
last order 26.
No,
just wait.
okay. Yes, madam. Yes, madam.
B. Sina, Lord shall inform the court as to whether respondent has acquired the graduation degree in science after his provincialization
Yes.
as tutor.
Yes, madam. Here, the graduation, there is, I have, misspelled, that is whether he has acquired qualification or eligible qualification or not. Eligible
What is
qualification.
the eligibility?
Yes,
as a tutor?
Is action science with.
Where? Under which provision? Ah,
No, my-
so as. So as the act.
Yes, yes. Then let him proceed with the argument.
No, you show us.
Yes, yes. Your lordship may kindly look into the act then, but.
Tell us which provision.
Yes, yes, that's the problem.
provision 6. 6, madam.
Wait, let me argue, man.
I'm assisting, madam. All right.
What's
Page
the, what's the
115, my lord.
115?
115,
In the meantime, you find out,
my lord.
Mr. Sinha.
No, I got it, man. I got it.
115.
My lord, 6.
Education and professional quality for teachers.
My lord. The services for teacher in venture
Venture
education
education
institution
from-
from primary.
This is primary.
My lord, primarily to degree
my
level shall be considered for promotion in the post of teachers or relevant teaching faculty in appropriate nomenclature as the case may be, subject to fulfillment eligibility criteria relating to educational and professional qualification as laid down under the following acts.
Right to children fair.
Rule, right to children
National
for
Council-
primary manner. Second, the National Council for Teachers Education 1993 and its regulation in force at the time of service. And Assam secondary is a higher manner than university in case of colleges. Madam. Now, if your lordship B, which I just
National Council for Teachers Education.
my lord, just I have handed over.
Ha.
Now,
So,
your lordship kindly see the National Council for Teachers Education. Now, page 6 of the my lord gazette notification I have just handed over, my lord. B, class for class 6 to 8. BA, BHC and 2 years
this
diploma in
is for tutor.
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 No, teacher, my lord. If
No, it's a,
he is tutor because he has no qualification.
huh?
He has no
His services has been provincialized as tutor.
tutor,
Then come to Rule 7.
my lord.
The tutor must acquire the prescribed education and professional quality within a period of 5 years
Within
from
5
the
years.
date of publication of order of provincial teacher and or tutors of the concerned medical in the proceedings and after appointment of required they shall be accredited to post of teacher within a period of 5 years from the date of publication. So for tutor also it remains the same.
My lord, it come and yes,
It remains.
within 5 years he has to acquire. My
So,
humble submission, my lord,
according to you, as per NCT,
at the
NCT, what is the qualification?
my lord, DHC, my lord, page 6, my lord. The gazette notification may kindly see, my lord.
Page 6. What is page 6?
My lord.
This is for class
6 to 8.
6 to
My lord,
8.
This is in respect of these schools, man.
Class 1 to 4. Then
Upper primary.
where it is?
My lord, page 6, my lord. Class 6 to 8. Your lordship got it, my lord.
6 to 8, yes. BA, BC and
BA,
2-year
BHC,
diploma in science.
diploma in education or such and such and such. So at the time of provincialization, this petitioner is a BHC with PLF degree, 2 years diploma course. So he passed, I have annexed all those documents. Now at the
About what the respondent number 7?
no, my lord, he only has in the science
Then
only. So at the time of
he
provincialization,
has to acquire within 5 years.
no man, here is question of acquiring this. When the suitable candidate is available, instead of my lord, your lordship.
See, look at this, education profession, the tutor must acquire the prescribed education professional qualification within a period of 5 years.
5 years.
If he has acquired BSc, BA with DL, whatever, within 5 years,
No, my lord, my humble submission, my lord, subject to correction. When a candidate of the same school having a requisite qualification as well as professional qualification, instead
that
of
is one
appointing-
thing, that is one thing you could have. But then if he is not required to be appointed as
My lord.
a tutor and granting them 5 years this time to obtain the professional education qualification, it can be. There cannot be a bar.
My lord, that can be, but instead
Whether
of-
he has acquired or not within 5 years.
that I do not know, but
Yes.
My lord, at that time of provincial election, my lord,
That's why whether shall I file an affidavit to bring
No,
back
you
the-
tell us, no.
Yes, I have acquired the qualification.
When?
When means what, my lord? In the year
What is your qualification?
now higher secondary science.
Sorry.
No,
In that
no,
case.
my lord, your lordship may kindly look into. Look into. He's misleading the code. Your lordship may
Oh,
kindly.
misleading.
Yes.
Is he
See,
standing
this
the
for
affidavit, ma'am?
appointment a teacher, it required the basic minimum qualification of BA, BSc
Not PSC, my lord.
with DL something.
Yes, it's not required, my lord. And it, there is, my lord, Act, my lord. Assam Education Promotion and Service Teachers and Reorganization Act 2017. Can you take that act? That act, my lord.
Which one?
That
This-
act,
this-
my lord, by which my service has been provincialized.
Huh.
By which act my service has been provincialized.
Hmm.
It is Assam Education Provincial Services Teacher the Reorganization Education Insurance Act 2017. That may kindly be look into, my lord, that book.
Tell us.
Yes, my lord. There your lordship will find. The rule one, my lord, rule one, my lord.
Read,
Yes,
read.
this, whatever he has says is not applicable in this case. The government in exercise of power conferred under provision of section 1(3) of Assam Education Provincial Service of Teachers and Reorganization Act so and so, so and so, so and so. The governor of Assam is pleased to notify that, except the provisions under section 4 and 8, the remaining provision of the said act are deemed to have come into force. So whatever he says, that act, that rule has not come into force, because section 4 says that NCT Act does not require in case of Assam. That notification said, my lord. 4. Can you look into the 4 now, my lord?
Read.
Yes, now 4. If we go to the 4, that NCT qualification does not come into play. Now 4 says 4(1)(3). No, sorry, 4(2)(3). The teachers and obligatory tutors to be provincialized under this act. Then we may skip to 2. Sorry, we can skip 1 and we may go to 2. Must have minimum qualification and professional qualifications as laid down under different acts, rules and regulations as mentioned under section 6.
Yes.
No. Section 6 or any other relevant state provision as the case may be. So section 6 has been exempted by the notification by the government of Assam. Section 6 is exempted, my lord. This has been exempted. This 6, whatever 6 provided NCT right to free education.
Read again, please.
Yes, my lord.
Read again.
Yes.
This is page?
Yes, page 114.
114, yes. Read again.
4(2).
Huh?
4(2).
Page number?
114.
Huh.
Teachers and obligatory tutors to be provincialized under this act.
Must have been working as a teacher in their concern. Mention so and so. Must have minimum education qualification, profession qualification as laid down under
Entire code is exempted.
different acts, rules and regulations mentioned under section 6 or relevant as the case may. Must have rendered. Why you are saying that it's exempted?
No, but why I say that section 4 would also cover section 6 also. This section has been exempted for operating into code.
What does it say?
Yes, there, in the rule.
All other
In rule 1, your lordship may kindly look into. Page 101. Page 101.
Under section 3 shall be deemed to have been provisionally on the date of Huh?
101.
Huh?
Notification is there.
Huh?
Government notification number so and so dated 12 May 2017. Heavy lordship got my lord.
Huh?
In exercise of the power conferred under provision of 1(3) of Assam Education so and so, 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 the governor of Assam is pleased to notify that except provision of section 4 and 8, the remaining provisions said act are deemed to have been come into force. So 4 and 8 does not come into force, come into play. But under section 4, section 6 is also there. 4 and 8 is exempted.
See, sir, why you are trying to, please try to understand this notification is for issued for bring into effect of coming into force of the act.
Yeah. Except section
That
4 and
will
8.
be from 5th of May. Others already notified.
Yes. Except section 4 and 8.
See, this is for a notification bringing into effect from the date of effective date of the coming into force
Yes. Except section 4.
of other acts, but section 4 and 8 already notified.
So section 4 and 8 doesn't come into play.
Sorry. Yes, who is for the state? This notification only talks about the other provisions, except section 4 and 8. It's not an exemption. It's a notification to bring into effect of the other provisions, which perhaps already the section 4 and 8 already been issued. Are you saying that section 4 and other section have not been notified? It doesn't have any effect.
Yes, man, it doesn't have any effect.
This is particular section notifying for bringing into, coming into effect of the bring in force of the particular provisions, the indicating, mentioning the particular date coming into force. Rest are already there.
Yes, please, only 4, others are already there. Section 4 and are not to accept section 4 and 8.
Sorry.
This is the meaning coming from this.
This notification particularly shows that except section 4 and 8, rest will come into from 15th of May 2017.
Yeah.
That means
Entire
other act and already there.
Other act means which one? 4 and 8.
Other provisions.
Other provisions.
4 and 8.
Entire act has come into on that day only.
Hmm.
On that day only, my lord. On that 5th May 2017, by gazette notification, this entire act has come into force only on that day, not before that.
Then whatever section 4 and 8.
Yes, 4 and 8 does not cover by this, whatever the governor was saying, does not cover by this act.
So
my lord, section 4 covers also section 6.
is it not is
on
not,
this day, this reorganization act has come into force.
then
5/12/2017.
hmm.
On this day only, this act has come into force. So there, while coming into force, section 4 and 8 has been not to be.
So let us assuming it has not brought into force, right?
Yes.
It talks about section 4 and 8.
4 and 8.
What about section 6 and 7?
Yeah, under section 6 come under section 4.
No.
Yes, there is there. There, my lord. Just now I have read. 2. Surplus 2 of close to 4. Section 4. Surplus 2 of close to section 4.
You come to, this is section 2 is definition, right? Section 2 is definition.
Yes, section 2 is definition.
Then
section 3 comes.
section 3 is what? Eligibility criteria.
Yes, eligibility criteria.
Then section 4 is
Section 4 is that these
teachers and other teachers to the government
will
servant.
not be applied.
Teachers to be government servants.
Section 4 will not be applied.
Then
So under section 4 there is section 6 is there, my.
sorry, how can there be under section 4? How can there be section 4, 6?
The act says, my lord. You lordship kindly go into my lord that 4 surplus 2 of close. That is.
It's not a subclause, it's a section 4. Section
4,
2 is definition, section 3 is eligibility
yes,
criteria.
section 4, then
Section 4 is the teachers
4,
and
1,
tutors to
2.
be.
Your lordship may come to 2. 4, 1, 2.
What do you mean by
Section 4. Section 4, then clause 2 of section 4.
You say, please come to page 14, 114. Section 4.
104.
Huh?
I'm reading that one.
So are you saying that section 4 is falls under section 2?
Well, what does it mean, madam?
That is
Section
why
2
I wonder.
No, section 2 is definition.
Then section
Section
3,
4
section 3
it
is
has
what?
own provision. Section 4 has own provision.
Then
In that provision,
Ah.
it also includes provision of section 6.
how can?
Yes, law says, I don't say, law says. My
Law doesn't say so, sir. I'm sorry.
But then
You are reading ulta.
No, not put down. I kindly look into 4, suppose 2 of
Are you saying that this is section 6 falls comes under section 4? Section 6 is a
part of section 6 come under section. That you also kindly look into must have minimum educational professional qualification as laid down under different acts, rules and regulations as mentioned under section.
Sir, I'm not understanding. You are saying that, see, let us admit that for a time being, except that section 4 and 8 has been exempted. It has not been brought into force.
4.
All right.
Yes.
What about section 6?
Section 6, part of section 6, whatever the qualification laid down for the state of Assam, it is not applicable. Because
Is the section 6 not a part of this act?
This section 6 comes under that 2. Mentioned under section 6 meaning what? Here it is written, section 6.
Which one?
In clause 2 of section 4. Subclause 2 of clause 2 of section 4. They must have minimum educational professional qualification. Every lordship government. As laid down under.
Let us assume that it has no force. Section 4. Omit section 4.
Yeah.
Whatever section 6.
Along with section 4, this part of section 6 also goes. Section 6 also goes, my lord, along with section 4.
How?
By section 4. Section 4 says that that section 6, part of section 6, the professional qualifications.
Mr. Sinha,
I do not know, my lord.
I do not know also.
I don't know.
You'll mad us. You'll make us mad.
No, it is laid down there,
This
my lord. I'm not. It's laid down there.
You are a seasoned lawyer. The provisions are not read like this. This is an act.
Yes, act.
Enacted by the competent legislature.
No. Yes, competent legislature.
There is a law in place to how to read, how to interpret the law. Let us assume or accept that section 6.4 doesn't have no, I mean, it doesn't apply. It has been exempted or it has been omitted, deleted.
Yes.
But section 6 and 7 remains.
Section 7 remains, part of section, other things are remains, my lord. Whatever the here section 6, the educational, specifically mentioned, must have minimum educational professional qualification as laid down under different acts, rules and regulation as mentioned under section 6.
It goes.
So section 6 of this, whatever qualification mentioned A to D,
so
A to D goes.
6 doesn't say, section 6 doesn't say that whatever is laid down in section 4, that will remain. Is it so?
Section 6 does not say.
Says?
Section 6 does not say.
So it has a different provision.
No,
Independent of section 4. Independent of section 4.
Section 4, this part, professional and education part,
Gone.
has been
Gone.
gone. So now which qualification now?
Section 6. Section 6. It has its own independent.
Section 6, that educational and professional qualification
Yes.
goes.
No.
That is the argument, madam.
That is not the argument. That is the total misconception of reading the act and provisions.
Yes, I
Sorry.
do not.
You must know, sir. You must know.
Now,
Let us not confuse ourselves.
now your lordship will find. By this act, all others some act has been repealed. Now the Assam
Section 6 has been repealed.
No. Section 6, part of section 6, which has gone into relating to educational and professional qualification are exempted.
No.
As per my law.
Where? Under which provision?
That 4 clause, subclause 2.
What is gone, I'm saying. For you, let's just accept that. I'll agree. Section 4 is not,
That
it is been,
requirement of BSc so and so has gone.
huh?
That qualification has gone, no need.
There was a provision
Yeah, there's
under section 4 with, where is the reference of section 6.
Yeah.
So that section, since the section 4 has not been brought into force by notification,
Yeah.
right?
Yes.
It goes.
Goes.
And there is a other section, section 5, forget about section 6. Section 5,
There.
section 7,
There.
other section are there,
There.
who has the force of law,
Yes.
who has been brought into force.
Yes, madam.
So therefore, if it is, if even the section which talks about certain sections
Yes, madam.
is done away,
Yes.
until that time that section which is had the reference of the provisions which has been done away still remains.
Still remain.
Then,
Yes, remain.
so forget about section 4. Let us look at the section 6.
Section C is whatever requirement he has just now, my lord, read into.
It has its own independent the provisions.
Yes, madam. Now.
Even if it goes, if there is a reference mention of the
Yes.
sections which has been which has not been repealed, that reference in the section which has been done away will not make any difference until the time that referred section by itself is not been done away.
Yeah. So now.
If it is yes,
Yes, if it.
your interpretation is
If it is
completely
applied,
fallacious.
then requirement of basic graduation doesn't require. Requirement is not necessary.
Sir,
Now-
section 6 provides
Section
NCT.
doesn't provide that one.
Huh?
Section 6 does not provide that NCT or.
Section 6 provides. Read section 6, please.
I know section 6.
Please read section 6.
Section 6 what says?
Ah,
Educational professional qualification of teachers.
yes.
The services of teachers in a venture educational institution from the
Yes.
primary
Laid down
level,
under the following acts.
under the primary level up to degree
Rules
level.
and regulation.
Considered for providential in the post of teachers, relevant teaching faculty, so and so, subject to fulfillment of eligibility criteria relating to educational professional qualification as laid down under the following acts and regulation. So A to D regulates. A to D says, now.
One of the thing is National Council for Teachers Education,
No.
1993.
It doesn't require for where. Now, your lordship may kindly look into the 7.2 now.
Ah.
7.2. 7.2. 7.2 may kindly look into. If such tutor fails to acquire such prescribed qualification within a period of 5 years.
Who is disputing?
It relates. my-
See, requirement is BA, BSc.
No.
Just listen.
Yeah.
I mean, it's not the one reading the one. I mean, the normally rule of interpretation. Number 1. What is number 1? Literal meaning. Number 2. Number 2 is harmonious. Number 3, potent substance. Right? You just cannot have that one harmonious thing. It depends on the I mean, act and rules, how you read into it. I mean, how you have to interpret it. Therefore, for a tutor, basic requirement is as per NCT. Suppose if you are appointed, you as per section 7 provides gives you the candidate or the tutor who had not had that basic qualification at the time of the provincialization. 5 years
5 years.
window is there. 5-year window is there. So you have to acquire. Now coming to your case, admittedly, when your service is provincialized, you are not having that qualification.
Yes,
By operation of section 7, you have to obtain that requirement.
That's why.
So whether you have obtained that or not.
I have been allowed to prosecute further studies of higher secondary science again by the department. Not by myself, by the
Sir,
department.
when you were appointed as tutor,
I was just higher secondary with 30% of marks.
huh,
I was to qualify because subsequently primary teachers qualification has been amended.
Huh.
So its requirement is 45%. 45% in the particular subject. So here particular subject is science. So higher secondary.
Where is the requirement under
So
that?
requirement, that's why the department, concerned department.
Where is that requirement under the law?
Yes, that is the thing, the rule 1977.
Huh.
We have to, that's why I am taking your lordship to there now again.
Huh.
That rule says minimum qualification is higher secondary assistant teacher in upper primary school, that is ME school, my. So higher secondary, if earlier qualification was just higher secondary, earlier. But subsequently it was amended. Amended and qualifying marks has been given that 45%. So that has been, I have been allowed by the department. So I have obtained this higher secondary again by appearing in the exam. So I have acquired now 49%.
Under what provision your service has been provincialized?
Yes, that provincialization is by this act.
Yes.
By this act.
Yes.
Now qualification, if we go for qualification, my lord, qualification we have to
precisely that is the reason the section 7 is provided.
Yes, 7 is provided. So
therefore, you have to obtain the basic education qualification of BA and BSc with diploma in elementary education within 5 years. If you have not done, gone.
upper primary does not require.
7-2, and he will be remain as a tutor. If he is not.
Yes, I have been given that. That's why I was
Within the
taking your look
specific
there.
Huh?
7-2, my lord.
7-2. Governor of Assam taken this matter, my lord, to the central.
7-2. If such a tutor failed to exercise prescribed qualification within 5 years from the date of publication of a provision, shall not be considered upgradation post of teacher after the lapse of period 5 years from the date of submission, and they shall continue functioning as per same terms and which are applicable to them before provincialization concerned person education institution. Okay. So if he doesn't this thing,
Qualify also, my lord.
he'll not be
Teacher, assistant teacher.
upgraded, but he will remain as a tutor. He may as a point. You come to that. Unnecessarily go into the.
I was asking.
Don't try to
7 to
misinterpret the provision. Yes.
My lord, since.
See.
My lord, I have seen.
Education and profession qualification of
That is
teachers.
correct. On the other day also, my lord, while submitting, my lord, since from the filing of the writ petition, my lord, my stand, my lord, if that's
See, it has boiled down to certain thing. See, section 6 provides for teachers, qualification and everything. Tutor is something different. That's why separate section provision is section 7 is given. Otherwise, you cannot be appointed without having a basic qualification. Now it appears that for tutor, this qualification is not required. The qualification of BSc, BA, whatever is basic qualification is BA, BSc is for teachers.
And professional is for teacher.
All right.
My lord.
So for upgradation, once you are provincial, your the services once if you want to upgrade it for upgradation as a teacher, you need to obtain this.
My lord.
Otherwise, nothing.
My lord. Now my submission from the.
So matter ends there.
My submission from the.
He'll never be upgraded as a teacher.
No,
but he can be
no, my lord. That is why I raised this question in the very motion day, my lord. When there is a candidate teachers having qualification, education as in professional qualification, instead of appointing him provincialized his service, you have opted a candidate who has no qualification.
As a tutor, not as a teacher.
No, question is teacher or no, whether he as a provincial tutor question is not there, my lord. Depriving me because only fact, my lord. Suppose depriving me, my lord.
Suppose 2 lawyers
My
wish to be enrolled as a lawyer. One the number one lawyer is having a PhD and other thing with LLB, obviously. And number 2 is just having a LLB. Whether just because the number one has a higher degree and more qualified, the number 2 can be denied from enrollment.
No, my lord, sorry. So far.
See, once you have the basic,
My lord, minimum.
it's not your case that for appointment as a tutor, it is required BA and BSc. It's not.
First.
It's not.
Teacher, my lord, that is correct. When the teacher.
If it is correct, nothing more.
No, my lord, when the teacher, my lord, your lordship kindly for a moment. When a teacher, my lord, when a teacher having requisite qualification, instead of appointing him.
It's not a teacher.
Well, it's a teacher. First teacher is there. That's why this honorable court, if your lordship kindly see.
No, it's a tutor.
No, my lord. Tutor is a later on. First, if there is a candidate for teacher, my lord, kindly see the definition. First teacher, not tutor.
After 5 minutes.
My lord, my lord.
Let me have some withdrawals.
My lord, my lord. My lord, for a moment, my lord, some submission. Suppose, my lord, your lordship, cite an example, my lord. For the purpose of appointment of AGS, my lord.
Where is the order? Where is the order?
My lord.
What the impugn order?
My lord, page 21, my lord. By virtue of this order, my lord.
Service of polling persons of recognized UPS tutor.
Tutor, my lord.
This is Jahidul Islam.
My lord.
Is respondent number 7.
7, my lord.
Yes. Then
Now I take your lordship, my lord. The page annexure 6, page 18, my lord. Annexure 6, page 18. Now relevant is page 20, my lord. Your lordship come at 20. 20. 20. Before that 19, my lord. 19. Here is the name of the teacher, my lord. Which was sent for provincialization, my lord.
Jahidul Islam.
Jainal Abidin is English.
Your?
Moinul Haq, Assamese.
Your?
Jahidul Islam, science. And the
Tutor.
Mijanur, maths and
Subject
science.
thought, present post designation.
Maths and science.
80.
Now I take your lordship.
Your?
Mijanur, my lord.
Mijanul.
Maths and science. Now I take your lordship page 1111 of the book, my lord.
11?
My lord, 1111 of the book. My lord, in the case of venture upper primary school, there shall be minimum 3 teachers or tutor, at least 1 teacher each for science and mathematics. Because I am BHC having maths, science and mathematics. 1 social studies and 1 is language. So now, when that science teacher with maths, my lord, it is recommendation of the district secretary of my lord, is available instead of provincialization having a requisite qualification, professional qualification, instead of provincializing his service, the one person who have no qualification for the post of science and mathematics, who is only higher secondary science, my lord.
Therefore, he has not been appointed as the teacher, he is appointed as
That is correct. No, my lord, my submission is when the teacher is available, only because of he is the brother of the headmaster.
We were not.
No, my lord, question of senior will not come, my lord.
UPS is tutor, science with effect from so and so.
Now, my lord.
Thank you.
If your lordship, my lord.
Mr.
My lord, your lordship, your judgment of this, your lordship judgment on another.
Mr.
A.K. Hussain, my lord. Now, one judgment of your lordship.
Yes, your name, please.
A.K. Hussain, my lord.
A.K. Hussain, learned counsel for the petition, and also heard which body state?
Your lordship judgment may kindly be one.
For respondent number? Have you filed affidavit?
My lord, file affidavit, director. My lord, admitting the fact, my lord, there is no.
S. Learned standing counsel for elementary education. And 1, 2, 4 and rest and B. Sina.
I am for 7, man.
5, 6.
5, 6, the school, concern
Survey is
school.
completed.
School you don't represent. Headmaster is not your servant. I mean, no, he is not a government service. It's not a government service.
That's why.
Headmaster is not a government service.
The venture school that time.
Now,
No, now, my lord.
Now the different school we have been appointed. Not this present school, in different school.
No, no, my
Kochua.
Yeah, no. In Kochua ME school, initially I was there. From there, the services of teachers have been considered provincial by the respondent authority. After provincialization, they have been posted in different schools.
Posting is something different. Initially is Kochua only. What is Kochua? Kochu.
Kochu from Kochua.
Huh?
Yes, we can say also from Kochu, it is
Both
Kochua.
the school, my lord.
in plural
5
sense, it is
6 can be
Kochua.
made part of it. Service is also complete.
Challenge made in this writ petition is to the order dated page 20, yeah? Page 20,
My lord,
21, sorry.
21.
0502 2021 passed by the who? Director Elementary Education, Assam, whereby the service of Sri Sahidul Islam, respondent number 7, herein, has been provisionalized as tutor within bracket science in Kochua Gao ME Madrasa. This stuff. Yes, what judgment you have?
My lord.
What does it say?
My lord, here in this case, my lord, since the science and maths is a core subject, in that case, my lord, social studies is a core subject, my lord.
It's for teacher,
Yes, my lord.
not for tutor.
No, my lord, tutor, two different categories of the, my lord, teachers.
See, that's what I'm saying.
My lord,
Once you are appointed as a
Well,
teacher,
my lord,
basic qualification has to be there.
Mm.
As per section 7,
my lord.
if a person is appointed as tutor, you have to obtain the degree, the required basic qualification to be upgraded a teacher
Well.
within 5 years. If you don't, even after appointment, you cannot be upgraded, but you will remain as a tutor.
No, it
There's
is,
a difference.
my lord, that is correct.
So
My lord,
appointment as a subject teachers,
my lord, it is the part of the, my lord, for example, for the purpose
so there's
of,
no bar appointing a person to appoint as a tutor.
no, my lord,
Any subject.
my lord, that is,
Okay,
my lord,
refer this subject so and so.
my lord, one Supreme Court judgment may can be relied on.
Salute. What Supreme Court judgment?
My lord, one,
In the same set of,
no, same status, my lord.
with the appointment of tutor and the teacher.
My lord, promotion and the,
What promotion?
no, why
no
I'm,
question of
my lord,
promotion.
ratio, why I'm relying this.
See, you are
ratio, my lord?
challenging the appointment of the responsible as a tutor,
My lord,
saying that he doesn't have the basic qualification
my lord.
as per section 6, whereas you have the eligibility criteria,
At the time,
the eligibility, qualification, everything at the
Yes.
time of consideration,
My lord.
right?
my lord.
So we find that for appointment as a, I mean, the provincialized as a the tutor, it is not required.
Giving go by the candidate who were at that
Why,
time.
otherwise, this will defeat the very provision of section 7.
My lord, it is a subsequent to that.
Yeah. Huh?
2017 Act, my lord, tutor has already been defined, my lord.
Ah.
Do not have the qualification.
Section?
2U.
To
my lord.
you,
That is there, my lord.
to you definition.
That is why teachers is also there, tutor is there.
Ah.
My lord, my
There's a
humble
difference.
submission, my lord, when
Had it been appointed, had the respondent 7 been appointed as a teacher, you have a solid case.
no, my lord, my submission.
You
is
had a
not
solid case.
My
He was
submission
not,
is-
he's not eligible at all.
My lord, a person for the purpose of Assam Judicial Service, a person has to be acquired AGS. He has to pass the AGS.
What is
Having
AGS?
AGS, Assam Judicial Service.
Huh.
Suppose myself is a lord.
Give the judgment, which I'll be, rejecting. I'll say that it's not at all relevant.
My lord,
Which judgment?
page, para 9 and 14, my lord.
What does it say?
My lord, so far at the time of either promotion, it is a, of course, promotion case. At the time of
It's for promotion.
teachers.
It's not a it's a promotion.
promotion, but so far
I'll
the
reject then and here and here.
social science teachers, my lord.
Hmm?
My lord, at the time of relevant time, my lord, the candidate has to be the acquired qualification. my lord.
Who is
This-
disputing that? Who is
that-
disputing
that is-
that?
So in that even, my lord, my lord, last paragraph.
Are you saying that he was not eligible to be appointed as a tutor?
My lord, page para 14.
No,
my
no.
lord.
Are you saying that he
No.
was not eligible to be appointed as a tutor?
No. So
Para?
my lord, para 14. That is why disturbing the respondent number 7, my lord, my service may be provincialized, even creating the supernumerary post, my lord. Para 14, my lord.
Hmm.
Of course, it is a case of my lord, teachers also
It's
home
not an
side.
appointment of the teacher.
My lord,
huh?
your lordship judgment is there.
Keep
my lord.
it. Keep it within yourself. You rely in some other appropriate cases.
My lord, if your lordship judgment is there, my lord.
Huh?
Your lordship judgment on the other day, my
What
lord,
judgment?
in my case, I have referred.
Huh?
Sohidul Islam, my lord.
Hmm. What does it say?
My lord. That may consider, my lord, paragraph 21, 22, and 23. Well, here in this case, core subject social science provincialization has been done.
Huh?
Core subject, like in this case, my lord.
This is a teacher, appointment of teacher.
Well, that is my case also me considered, my lord, by the director, my lord. Your lordship, that observation may be given, my lord. Since maths and science is a core subject, my lord. So in that case, my lord, social science has been skipped. Now, that's why I'm praying for, my lord, give a direction to the director also. Let it creating a supernumerary post, my lord, may consider.
Obliged. Obliged.
We'll pass the order.
My lord. But, my lord,
Just give that judgment. And that's better you keep it yourself, but then if you insist, it's ticket, keep it here. Keep it here. Only to consider and rejection.
my lord,
Only to consider
I
and
am relying
consider for rejection.
because of the fault by the respondent.
See, promotion is quite, it's a total
My
different
lord,
thing.
ratio, my lord, that is correct. I'm saying so, my lord.
Okay, thank you.
My lord.
Huh? Order this.
So that prayer, my lord, let them create a supernumerary post, my lord. The core subject may be.
This will be given to her, Madam Anamika. No data.
My lord.
Huh? Yes.
My lord, I have
Yes, your case is?
Item 4, Lord.
Yes.
so,
Shortcut or long cut?
shortcut.
Shortcut.
So, given with liberty to file appeal before the director.
Any objection?
Secondary education.
Heard,
And
Mr.
the status as on today shall be maintained till dismissal of the.
No, that cannot.
We're not saying anything. You seek the appropriate relief there because appeal, if you want to file appeal, they are not barred from passing any order. They are the appellate, the authority who can consider. We don't usurp. Let us not usurp the power of the authority. Right? Heard MMU Muhammad Learned Counsel for the petitioner. No. MU Muhammad Learned Counsel for the petitioner, after arguing the matter at some length, fairly submits that at some length, fairly submits that he may be allowed to withdraw this writ petition with a liberty to file appropriate appeal before the
Government in secondary.
before the authority. In terms of what? What is that? In terms of
7.
clause 7. In terms of clause 7
It is para.
of clause 7 of office memorandum dated 22/09/2016. A scheme. Office memorandum dated so and so, dash
And also
Shiksha Khetra dash a scheme for amalgamation and merger of different schools. Mr. SMT Learned Standing Council Elementary Education, Secondary Education is present. The considering that the appeal would lie before the government in terms of the clause 7 of the office memorandum dated 22/09/2016, the prayer for withdrawal is accepted. Accordingly, writ petition stands closed on withdrawal with the liberty to the liberty to approach to file an appropriate appeal before the government.
And presently that notification no longer exists, Lordship. The 2021 notification is there, Lordship. So it will,
This
they
also
have to
said-
follow this one.
Huh?
They have to follow this one, Lordship. At a
Then-
new notification, 2021.
Is there any provision?
Point 19, the same, Lordship.
Point 19,
19. I can do this.
clause 9.
Point 19, Lordship. Serial number 19, Lordship, mechanically period, the same condition. But this will prevail, Lordship. And now this notification will prevail.
Clause 19. Then in that case, last, in terms of what is it? The clause not, clause 19 of the office memorandum dated 03/08/2021, which is perimeteria with clause 7 of office memorandum so and so, so and so. We'll just correct it.
Oblige.
Okay, so one personal inconvenience, right now my senior is not available in the court.
Please raise your voice. Little louder.
Personal problem, my senior is not available in the court right now.
So
Lordship,
petitioner,
kindly-
respondent.
Yes.
Yes, Mr. Sharma.
My lord, this matter relates to assessment or re-evaluation of answer script for the year 2022 HSH examination. This case is covered by the revision bench order, and the counsel for the SEBA was directed to verify and to make his submission.
Yes,
He said,
Kindly fix the matter at 2 PM, Lordship.
2 PM. Ending. If it's covered case, inform your senior. Have you annexed all those cases in the writ petition?
therefore, the connected appeal has been tagged, my lord. Writ petition has been tagged.
Which one?
Connected matter has been tagged. I have also furnished the copy of that.
6226.
Yes, ma'am.
Huh?
Yes.
I see.
Wait, please, Lordship.
Yes.
Lordship, here in this matter, we'll file our affidavit. Lordship, may allow 3 weeks time. Lordship, may fix the matter immediately after Bihu.
Yeah, what?
We'll file our
And
affidavit.
heard MSK, they be learned counsel for the petition on the prayer of Mr.
As a last dance.
PN Sharma, learned counsel for the learned standing limitation. Further 3 weeks time is granted to file affidavit.
My lord, as a last chance, because they took several times, my lord, to file affidavit.
What is
Okay.
the matter? What is
It
the
is
matter?
provincialization of the school, my lord. School was established in the year 1985, my lord. And there, everything is, requirement is fulfilled, my lord. And
19
name is, school's name was also shown in the online, my lord. But school was not promised. That is my case.
1985 I was in class 4.
My lord?
1985 I was in class 5. Sorry, not 4.
I'm also a school at the
Okay.
time. I was.
Your
Yes.
lordship, the matter may be kindly adjourned for today.
Why?
My senior is out of session.
Yes. Mr. Your name?
My name is BK Likhok.
Huh?
BK Likhok,
You're from?
Jorhat, Assam.
Likok.
Hi.
Okay. Your name is there.
It not there, sir.
Mr. P.K. Leacock.
Likho.
I don't know. You just give your name. Learned counsel appearing on behalf of Mr.
SSS Rahman.
SSS Triple S Rahman, learned counsel petitioner, submits that Mr. Rahman has some personal difficulty today. Therefore, press for listing of the matter after 3 weeks. Prayer is allowed. List after 3 weeks. MS,
Appearing for respondent number 9.
who are you?
I am the respondent number 9, Lordship. I am appearing on behalf of Mr. D. Das.
MS so and so, learned counsel. Your name, please.
A.M. DeCosta.
DeCosta. Learned counsel appearing for respondent number, Mr. D. Das, learned counsel for respondent number 9 is present.
And I am for the respondent number 2, 3, and 4.
Then are present. You, Sharma.
2, 3.
You, Sharma and MS so and so. Standing counsel, elementary, secondary education, and MS so and so, are present. Yes. Why all your name has to be recorded? You have not said anything. Why I should record your name? Anyway. R Boro. For respondent number? 4. And why you have kept quiet? You just take the name, huh? It will be confusion, huh? Take all your name and give it. Yes.
Check.
Yeah.
They have an interim order has been continuing, and they have taken an interim order. Lordship, already a case is pending in the.
So he has not said anything about interim order. You keep quiet.
Lordship, already a case is pending regarding the same matter in the lower court. So if your Lordship may.
So you want that the matter should be sent to lower court.
Already the matter is pending, Lordship.
Where?
In the civil judge senior division.
Go take it to the civil judge.
Your Lordship may dispose this matter.
I don't know anything. I don't know. I have not opened the file because he has sought for an adjournment, which you have not objected. Okay, thank you. Next. Yes.
Paying for the respondent number 6, 7, and 8, my lord. I was directed to produce the original records of proceeding books, as well as to I have to submit the additional affidavit, my lord. But some time is required for the respondent number 7 is under medical treatment, my lord. So some time is required.
In this regard, I would like to submit few lines, my lord. Actually, I am not also feeling good to raise objection against my learned senior friend.
What? You are not feeling
good to raise objection against the submission of.
You are not feeling good,
my lord.
To raise objection.
My lord. Actually, what happened? 8/1/25 notice was issued. 6/5/25.
Okay, thank you. If you are not feeling good to object,
No, my lord.
we'll grant some
let me submit my lord.
And Mr. Jiuddin.
Let me
Jiuddin.
Let me submit.
You are
my lord.
Jiuddin, sir?
I am A.K. Azad, my lord.
Are you objecting to his submission?
My lord.
You want to argue the matter?
Yes, my lord.
Argue it. Then why you are saying that you are not feeling good to object?
My lord, let me explain, my lord, on that part.
Why, if we are not going to dispose of the matter, if you are not going to argue, when you are not
I am ready to argue, my lord. I am ready to argue.
What is the matter about?
My lord, matter about my lord, selection of my lord, SMC president, my lord.
Very appears to be very serious and important matter.
My lord, my lord.
Right?
That is why the record was called.
My lord, is it not a serious
appointment of SMC?
SMC president, is it
Yes.
not a
Yes,
serious
argue,
matter, my lord?
argue. Please.
My lord, at first notice was issued to the respondent number, private respondent 8/1/25.
Sir, you want to argue, please argue the matter.
My lord.
Don't refer all this.
My lord, in this case, my lord, I am
Ready?
only on the
Ready? All of you are ready?
I am only on the ground of, my lord, before my removal, whether I was given to the reasonable opportunity to or not, my lord. On that point, I would like to argue, my lord. My lord, I was elected president of that school. After my election, my lord, raised some vague allegation by the respondent number 6 and 7, stated that I have malified practicing during my tenure and some demanded some illegal demand, made some illegal demand to the respondent number 6 and 5, and submit an application to the authority without giving me any reasonable opportunity to heard my part, to submit my part. I have removed, my lord, from the post. Now, my lord, private respondent already filed affidavit in opposition whereby they have brought on record peon book regarding service of notice upon us, upon me, my lord. And by that peon book, my lord, they have admitted that, my lord, they are tried to serve the notice through my minor daughter, who is the student of that school, and tried to serve the notice upon me by the Sokidar. Whereas in that affidavit, they have stated, my lord, in page 58, their affidavit, my lord. Page 57, my lord. Page 57. In the paragraph, my lord, in this regard, the ensuing deponent further begs to state that in relation to the meeting dated 6/6/24 and 8/6/24, the due notice general as well as individual had been issued, including to the writ petitioner through his daughter and through Sokidar of the school. But despite of a receipt of such notice, though he refused to sign on the peon book, the writ petitioner did not present in the said meeting. Malab, in that situation where noticee refused to accept the notice, what alternative modes is there to serve notice to the noticee, my lord? That is clearly stated in the CPC, my lord. Order 5, Rule 17, my lord. I would like to read out the same subject of lordship permission, my lord.
Are you trying to schooling this court on CPC?
My lord, my lord. Regarding service of notice issue relating to.
Are you trying to schooling this court on CPC?
My lord, in support of my case, my lord, subject to lordship, I would like to submit.
Are you or are you not?
My lord, my lord.
Are you trying to school this court?
My lord.
Then take me a class in some other day.
My lord,
not in the court.
My lord, in the regarding service of notice, my lord, to the noticee, my lord. Here is provided Order 5, Rule 17.
That's why I'm saying, are you trying to schooling me on CPC?
Oh, no, no,
this
no,
court?
my lord, no, my lord. I'm sorry, my lord.
Okay.
In that section, I'd like to submit on in support of my case, my lord, whether I'm trying to submit, my lord. They have not served any notice upon us for my removal. And
had Mr.
A.K. Azad, my lord.
A.K. Azad.
At last, my lord,
You are Azad, be Azad.
My lord, one line I would like to submit.
Plus two, I mean, A.K. Azad, learned counsel for the petitioner. Heard, huh? This court on 19/02/2026 directed the respondent number, learned counsel for the respondent number 6, 7, and 8 to file an additional affidavit enclosing the correct enclosures and to place the, as well as to place the original records of the managing committee. However, Mr. M.K. Sharma, learned counsel for school respondent 6, 7, and 8, submits that due to health issues, health problem of the respondent 7, the required additional affidavit and the original records could not be, the required additional affidavit could not be filed, and the records could not be obtained. Please stop. Therefore, press for 2 weeks time to obtain, to file the appropriate additional affidavit as directed by this, and to place the original records as directed by this court, huh? Next para. Mr. Azad fairly submits that. What you have said? In fact, submits that he is not feeling good to oppose, huh? He's not feeling good to, what is your say? What you have said?
My lord,
You are not feeling good to
actually,
oppose.
I am trying to show respect to my London
Yes.
council, my lord.
That's why I'm
There is,
recording your
earlier, So
submission.
many occasions they have taken time.
Yes,
That
you-
I would like to.
See,
put to the
Mr.
note.
Azad, we learn every day, all of us.
My lord.
So I'm learning something today from you. Yes,
I'm
that means that he is not,
Feeling good to raise objection.
we'll say, he in fact doesn't object to the, in fact, he would normally not object to the prayer of the learned counsel, Mr. M.K. Sharma. However, due to pressing, in view of the grievance of the petitioner, the matter may be taken up for disposal on the next date.
My lord.
Right. Next para. Considering above that this matter will be listed after 2 weeks. On the next date, Mr. Sharma, learned counsel for respondent 7 and 8 to place the original records, honor before Mr. Sharma to file additional affidavit and to place the records on the next date. Just arrange that. Arrange kar lena. Arrange kar lena. Yes,
Date, my lord.
after 2 weeks.
After, my lord, if possible, date fixed, my lord.
Give after, then in the case, give after 3 weeks. 6 or 7? 6.
6th April.
To be listed on 6th. 6th April.
I'm always.
Happy?
My lord, at last I'd like to express my apology, my lord.
What? Nothing,
Actually-
nothing.
Actually, my lord, out of a 3 years tenure, already 2.5 years gone. That is why I'm so.
We could,
My lord.
it's demonstrate on your,
My lord.
forehead,
I will let you know.
your anxiety. Your anxiety, it shows, clearly reflects.
My lord.
All right, don't worry.
I'm okay.
Lordship, in this case, I am paying 2 week time. So yesterday, my respondent filed an affidavit in opposition.
Mr.
L.R. Majumdar.
L.R.
Majumdar.
Majumdar, learned counsel, or on the prayer of Mr. L.R. Majumdar, learned counsel for the petitioner. A week's time, 2 weeks. 2 weeks time, 2 weeks time is granted to file affidavit in reply. List.
Lordship, a date may fix after vacation, Lordship. Any date, Lordship. After.
Then in that was 3 weeks. We'll say 3 weeks. Yes.
The instruction.
What is the instruction sought for? What is the matter, sir?
My lord, we are seeking, my lord, pensionary benefits for all pension rules, my lord.
Okay. Under all pension rule.
Yes.
You have been,
I'm a, my lord, Shokidar, my lord. Kindly come to, my lord, page 44. There is a judgment, earlier judgment of this honorable court, by which I am covered, my lord.
Okay.
Page 44, last
It's a covered case.
Yes,
Or are you seeking similar relief?
similarly.
Similar relief. Page 44.
Yes, sir. In fact, I was also a petitioner, my lord, in that petition.
Then?
I'm petition number 9.
Where is?
Page 35.
Page 35.
Yes, my lord.
Your petition number 9.
Yes, my lord. Dipendra Chandra Talukdar.
Huh?
Dipendra Chandra Talukdar.
Page 35.
Now, my lord, page 44, last para. All appointments made would be prospective, but will carry the benefit of past services for the purpose of computation of pensionary benefits.
Yes.
So I'm not being granted that, my lord.
Others have been granted.
Yes.
Yes.
Lordship, the department is preparing the instruction whether that petitioner's case will be covered by this case or there is some other.
Obviously, is the.
But petitioner was regularized on 2016.
No, he is. Schedule number 9 in this thing, page 35. Appointment against all appointments made would be prospective, but will carry the benefit of past services for purpose of computation of pension benefit. Huh?
Without instruction, Lordship, I cannot comment on this, Lordship. That instruction is being prepared, Lordship. It will get shortly, Lordship, within a week.
The cases of petition in each of the case will be considered according to the norms currently so and so. The chief secretary will so and so examine the case of in the present partnership and such other. Any consideration has been made?
Nothing, my lord.
That I will get the instruction, Lordship.
Let them. Not Mr.
Arch Chakraborty.
Learned counsel for the petitioner. One petitioner.
Yes, single.
Delay. Considering that the issue raised in the present proceedings has already been dealt with by this court in a by an order dated by a judgment dated 2003 in a bunch of writ petitions, including the the case and the writ petition filed by the present petitioner, Mr. P.P. Datta, learned standing counsel, secondary education, is directed to obtain instruction list accordingly. Let this matter be listed after a week. We'll see.
All right.
Have you filed the affidavit? What is the matter?
Excerpt J, page 14, my lord. The petitioner has misappropriated rupees 70,000, my lord.
Yes, who is for the petitioner? Hmm?
He was a headmaster, my lord. Come member secretary.
What is the order? 40.
Whereas Mr. Abdul Jalil Borga, HT of DO Hailakandi of Hailakandi district was placed under suspension by DO Hailakandi by order num. There's this malad. Due to gross financial misappropriation, misuse of
Whether there any departmental proceedings?
he was, we have filed our affidavit here, mentioned that he was served notice, malad, he is not appearing.
He's still working. Still working.
That,
Non appears for the petition on call. Mr. G. Pego,
Standing under elementary.
Standing Council, Elementary Education
Yes,
is
ma'am.
present, who submits that affidavit in opposition has already been filed. List the matter after 4 weeks. There's so many hearing. Yes.
We need some time to file our affidavit, my lord. Affidavit is ready, but we have not received the annexures, my lord.
Their loss, because they last 2 of them, they take time.
Mr.
And they go.
NJ Gogoi, then counsel for the petitioner. On the prayer of, you have said that the last occasion sent for betting.
Not cheap.
We have received, but we have not received the annexures, my lord.
Okay. On the
Please,
prayer
we
of
could
next
not
prayer,
file
MS N. Pukhar, London Standing Council, Elementary Education, further 2 weeks time is granted to file.
You can fix their loss.
List the matter on.
Board after BHT.
9 April, है ये सब.
9 April,
Election.
nobody.
Bihu Pasupati.
After.
Diplo.
Published.
In item
May
30
I
and
please your lordship,
31, my lord.
the last order may kind of be looked into.
That
lordship.
is what we want to
On
submit.
appearance.
Let us submit first. That is why we want to submit, lordship. Yes.
Yeah.
My lord, as per last order, my lord, we have to file our affidavit today.
Not
But-
today. Or 10. Okay, okay.
My lord, may kindly see the last order, my lord.
Yes, I give them only 10.
Yes.
My fault, my lord, I forgot to communicate the order, my lord. And secondly, my lord, the order has not been uploaded in the website. Skip from my mind, my lord. So I'm praying for a little accommodation for today, my lord.
How personal appearance can be dispensed on what basis, lordship? Today, failing to file affidavit in opposition on or before 10.
He said, fairly said it's his fault.
But
It's my fault, my lord.
Have some consideration on your friend. Tomorrow it may,
yeah, there is a
you may
personal
have the
appearance. man.
same.
Leave it before your lordship because there's a
See,
personal appearance that
To not improve the case,
that-
lordship, let us file a
even
affidavit.
that contains
Normally, I don't believe, this court doesn't
on
believe
how
in
many
technicalities.
occasions they took time losses. I am apprising this on our court, how many times they took time to file affidavit.
Today,
And
they are filing today.
not filed. No
Huh?
copy served to us.
They are filing today.
No, my lord, I'm
Even not
I'm
filing
fairly
today.
submitting, my lord. I forgot to communicate it, my lord. And secondly, my lord, order has not been uploaded in the website. That is why it was kept from my mind. So I could not communicate with the
When it
department.
has been uploaded, order?
When we check it, it's not uploaded. We check with the lordship, we do not find that particular order.
Still, it's not uploaded.
Still not uploaded. It is
Still not uploaded.
That is the.
No, in
it
fact,
has-
earlier-
in fact, upload, not upload, when the order is passed before in the presence of the learned counsel, I
Yes.
mean, you cannot just say all this thing.
It was
present.
passed in presence of me, my lord, and it is my fault, my lord. I forgot to communicate with the department, my lord. But right now we have received some instruction, my lord. So, my lord may give a week time, my lord, so that I can file it, my lord.
Intentionally delayed because in 2013 matters I am fighting for that and earlier 5th, 6th occasion they took time. Every time they stated we received instructions.
Okay.
Since my learned friend 1 week time lordship, they,
So he's taking, he's not, he's taking the blame.
Lordships on 30th of March,
Yes, my lord.
Mr. Heard, Mr.
FU Borboya. FU.
F.U. Borboya, Learned Counsel for the petitioner. Huh.
One.
I'm appearing on behalf of respondent number 4 and 5.
Ah. Who is respondent number 4 and 5?
Headmaster of this.
Managing committee, my lord.
Managing committee.
Mhm.
That will come secretary.
The who was supposed to appear today? Directly.
Director Elementary Education.
Okay.
Secondary, not elementary, secondary.
Although, no, this court on 16/02/2026, after hearing the learned counsel for the parties, granted time to file affidavit to Mr. N.J. Kathinia, Learned Standing Counsel, Secondary Education Department. On or before 10/03/2016, and further directed and in the event the affidavit is not filed before the next date of listing, the Director of Education Assam Cell, the Director of School Education, Secondary Education, to be present in the court along with the contemporaneous records. However, today Mr. N.J. Kathinia, the Standing Counsel, submits that in view of, due to his fault, the said order could not be communicated. More so, the order that is 16/02/2026 has not been uploaded. Therefore, well, tendering apology for such omission, says that he may be granted a week's time to file the affidavit and to place the records as directed by this court. As directed by this court. List of considering the submissions of Mr. Kathinia, the Standing Counsel, that and considering that the omission to considering the submissions of Mr. Kathinia, the Standing Counsel, that the omission to communicate and to file affidavit cannot be attributed to the Director Secondary Education. And taking the lenient view, I deem it appropriate to grant a week's time to file affidavit and to place the records as directed by this court on 16/02/2026. Accordingly, let this matter be, as agreed to by learned counsel by the parties, let this matter be listed on 30th,
30th of March.
30
Yes, my lord.
03/2026. MS so and so, what do you want to say? Want to say anything? So and so. For respondent number 5, submits that she has already filed affidavit on behalf of respondent number 4 and 5. What is the issue?
Issue is regarding non getting my salaries from date of initial appointment.
Yes.
Yes. And my interim order is there, lordship.
Interim order passed earlier
Earlier
shall
shall
continue. The requirement, the direction for personal appearance of the director secondary education is dispensed with.
My one submission, last order, since not been uploaded, lordship, the registry may be directed to upload.
It's okay. It's okay.
Lordship.
That's why I've indicated. Even if it's not uploaded, maybe for technical reason, whatever, technical problem, when the order is passed in the presence of the learner, you should not, I mean, all right.
Obliged.
Be careful next time. 30 and 31, right? 30 and 31. 30, 31 all.
30, item 30, 31.
Yes, yes. Continue it too. Yes. Yes.
Lordship has already partly heard the matter. My lord, here, after the petition termination.
I remember.
Yes.
Because it is for appointment for service, reinstatement or something like that.
Yes, my lord. So, my lord, after termination,
Ha.
my lord, he committed suicide. So, my lord, the petitioner father has stepped into the suit, my lord. Now, petitioner father is before your lordship. So, my lord,
No, that's why I find it, I mean, difficult because.
Yes.
So that day we have deliberated.
Yes,
That's why this was fixed today to obtain instruction.
Instruction, my lord, is that, my lord, now I have tried to communicate, my lord. And father is there, but and wife already, my lord, left the house. So, my lord, now only father is there. So, my lord, my submission was that, my lord, that order was stigmatic because foundation of the order that there was communication immediately when he, my lord, came from the camp. Then.
No, Mr. Kalita, I've understood. Not on merit. Now, suppose if we find that you have a merit.
Yes.
What relief we could grant to your father?
My lord,
we will not be able to say, I mean, we understand it may be, let us assuming that, accept that for a time being that it may be stigmatic.
Yes.
What can unfortunate have happened?
My humble submission to that aspect, my lord, that if your lordship finds that order is, impugn order is illegal, my lord, and impugn order is set aside, then, my lord, person will be considered to be in service, my lord. Then, my lord, at least, my lord, for survival of the, my lord, only the old ailing father, my lord, at least, my lord, he was in service, my lord. So, termination order is illegal. Some financial benefits will be his father will be entitled. That is my only, my lord, submission.
I don't.
So, question of reinstatement, my lord, now not arise.
This is difficult. Reinstatement spent also with back was still so and so sitting.
After filing, he committed suicide. After filing of the case. And thereafter, he died on 26/12/13. After filing of the case, immediately after filing.
Whatever the Pinku Kumar Paul case.
Pinku Kumar Paul, my lord, Parseki. My lord, he ultimately his order was, court held that his order was stigmatic, and so my lord, he was directed to be reinstated.
So that's all.
Yes, my lord, because he was as he was alive, my lord, so he.
That's
he
the
got
problem. That's why we have adjourned the matter.
Yes. I only has to the, in that aspect, my only submission is that, my lord, if the order or the impugned order is found illegal, my lord, lordship is pleased to set aside that order, then the person will be treated as in service, my lord. And if, my lord, he is treated as a service in service, my lord, then financial benefit his legal year will be entitled for, my lord.
Yes, madam.
In the Pinku Kumar case also, court, the observation of the court is that if the petitioner deliberately committed any offense under the 1949 Act, that is CRPF Act, my lord, which is less heinous offense, can attract only a minor punishment under Section 11 of 1949. And under Section 11 of 1949, dismissal or termination is one of the, my lord, punishment, my lord. That is for the minor punishment, also dismissal is one of the punishment, my lord.
This is termination.
Yes, ma'am.
Yes.
So what do you say on the merit?
So, my lord, on merit, my lord, that is the same ground, same Pinku Kumar case, my lord, that is the same incident, my lord. Here, honorable.
Out of same incident.
Same.
Out of same incident.
Sorry, similar incident, not same, my lord, similar incident. So, in that case, honorable court, the observation of the court that he may be punished under Section 11. If the Section 11 is attracted, then Section 11 termination is the punishment, my lord, under Section 11. So there is no dispute. On merit, my lord, this is not illegal, my lord. Here in our case also, termination from services. On merit, this is also not illegal if we go through that Section 11 of 1949 Act, my lord. So my humble submission that this is method. He is not entitled for any because from his appointment was in 2004 and dismissed on 2006, my lord. So he is not entitled for any benefit also, my. And on merit also, if we go through the act also, and the termination is not illegal, my lord. And punishment is also not illegal, my lord.
What is the impugned order? Yes. Kalita, what is it?
At page, my lord, 56.
Have you filed affidavit?
In affidavit, my lord, they have admitted that person as he deserted the office and it is considered as a misconduct, and so his termination order was issued, and there is no illegality. That was their submission. So my submission is that, my lord, even if person is in probation or in contractual, if, my lord, you impose him a major punishment which is stigmatic in nature, then you have to follow the principle of natural justice.
Where it is, the impugned order is where?
My lord, page 56, my lord, Annex 10.
56.
Yes.
Notice of termination. Yes. Any judgment you would like to rely?
Yes, my lord. I have already submitted, my lord.
Where?
One judgment, my lord, I have submitted.
Only one?
No,
yes.
one is Pinku Pal, my lord. And one is Pinku Pal.
Brijesh Kumar.
Other is, my lord, Deepti Prakash Banerjee, 1999, 3 Supreme Court cases.
No. Pinku Kumar is there.
Yes, my lord.
Then?
One is, my lord, Deepti Prakash Banerjee.
Which has been relied in this case?
Yes, my lord.
Deepti Prakash, well, the answering question is to what circumstance termination. Yes, then?
Other is, my lord,
Brijesh Kumar.
Brijesh Kumar.
It's there. There. Huh? Where is this?
And one is, my lord, our High Court, my lord, judgment. This one, my lord. Our High Court judgment.
Which one?
I have flag mark for it. Yes, Brijesh Kumar is also there, my lord.
It's already there. Para?
Para flag mark, my lord.
Then other judgment,
One
Pinku
Brijesh
Kumar.
Kumar, my lord, I have already given.
Brijesh Kumar, para?
Para, my lord, 14 onwards. 14, 15, 16, and 19.
You just mark it, take it, huh?
Brijesh to 9.
Brijesh is here. Para?
Para 14, 15, 16, 19, 20, my lord.
Then Pinku?
Pinku, my lord. Para 14, 15, 16, my lord. And 17.
So many paras. I thought 17, 20. This would be right there. The Brijesh, Pinku, then
And Dipti Prakash Banerjee, my lord.
where is Dipti Banerjee? Why, that has been relied in Pinku.
Yes.
Then this is para?
Dipti Prakash, my lord, para starts from 20, 21, 27, 35, 37, and 41, 42.
Just write this. Heard Mr. N.K. Kalita. Any judgment you would like to rely?
In fact, is in our paper in para number 16, my lord, Pinku Kumar judgment. Here the court observed, I have just, I have already submitted that, my lord. It is a petitioner deliberately committed any, here also petitioner committed offense, my lord. And under section 11, and kindly come, if honorable court come to section 11, then the punishment is termination for more, less.
CRPF Act.
CRPF, less heinous.
CRPF Act.
Yes, my lord.
Heard
So-
Mr. N.K. Kalita, learned counsel for the media, and also heard Miss M.S. Agia, learned CJC for respondent, all respondents. Hearing concluded, judgment reserved. CRPF Act. Put it here. Okay. Pasta se na abhi. 8.
Admission.
Hmm.
In the HSLC examination in India 2012. In respect of other subject, I have secured 88 marks. In respect of one subject, I have secured 60. And there my percentage of marks were come down. Some is paper, some students were not evaluated even for right answer, no marks were awarded. Such a situation, Standing Council of Sabha submitted that all the answers have been disposed of. Such a situation,
What judgment? Yes.
Yes, my lord, the petitioner appeared in the examination in the year 2022. Result was declared on 7/6/2022, my lord. And as per norms, answers keep destroyed in the month of October, that is after 4 months. And thereafter, this instant writ petition was filed on 4/5/2023, that is after 1 year. As per both norm, my lord, after 4 months from the declaration of result, we dispose of the answer scripts, my lord. And therefore, my lord, without the original answer script, it is difficult, my lord, to put forward the, my lord, the answers of the petitioners, my lord. The same situation of and our regulation provision is there, my lord. Standing council of SEBA was other. Because as per SEBA regulation, answers were to be reserved for 4 months only. Then also, my lord, has directed the authorities that being the position, we direct the respondent for to examine the answer sheet. The petition of the respect of yes, assumptions. But by relaxation,
Suppose if it is disturbed, how they can re-evaluate?
Even after the disposal of the answer sheet. My lord,
Huh?
paragraph 11 of the.
It's okay, but then practically.
Yes, my lord. On the basis of my lord answer sheet, both have been photocopy has been submitted to us. Photocopy of the answer sheet has been submitted to us. That has been connected to the requisition. That basis, that it is their documents. On that basis, if unevaluated answers were not, right answers were not given any marks, then my lord, the events.
You saw the judgment to him.
Yes, my lord, we have seen, my lord. My lord, that in that case, my lord, the provision of our regulation was challenged, my lord. Yes, my lord. And but here, my lord, no provision has been challenged by the petitioner. And paragraph was listener, 27, okay. Leading to
What do you say?
my lord, in the judgment, my lord, paragraph 31. 31. That being position of. My lord, kindly see, my lord, that being the position, we direct the respondent number 2 and 3 to re-examine the answer script of the petitioner in respect of Hindi and general science subject of the HLC examination 2017 within the parameters of regulation 48 or 47 of the examination regulation, as the case may be. While carrying out the said exercise, if it is felt that the relaxation clause under regulation 51 or 50, as the case may be, is required to be invoked, SEBA may consider invoking the same. Beyond this, we express no opinion.
Your examine, it was rechecked.
Yes, ma'am. There is no authorization.
Then if there is nothing to be altered, then after rechecking, if nothing is to be altered, then How it can be just because you want the rechecking?
After hearing the discrepancies of mark. I have filed an affidavit.
Legal sector. Heard Mr. Answer, my learned counsel for the petitioner. Huh?
Page 90, my lord.
Ah, well, no, it's not possible. I think it requires.
Questions which were not evaluated by the attendant. Even no marks were given. Right or wrong, no marks. Unattended. There is a attended question. Have to verify.
My lord, provision is here, but my lord, he approached this honorable court after 1 year of the
If
declaration. of the-
provision is there, what?
My lord, regarding, my lord, kindly see our regulation, my lord. I have
Heard
provided.
Mr. Answer, my learned counsel for the petitioner. And Mr.
DK Roy.
DK, learned standing counsel.
Seba, my lord.
Seba, huh? Buildings are complete. Additional affidavit you have filed.
Yes, my lord.
You reply, have you replied? You have replied?
My lord, replied, my lord.
Against the additional affidavit, they have not filed.
If you want to file any, it's okay. If not,
Oh, yes, my lord.
huh?
Yes, ma'am.
Huh?
Yes, my lord, we will file, my lord.
Next question. As directed by this court, the petitioner has filed an additional affidavit bringing on record. No, additional affidavit to the effect that the questions, huh? Although the respondents has rechecked the paper, however, there's no what do you call?
Alteration in mark.
There's no alteration of the marks. Despite the fact that the what do we say? Alteration, how can the yeah, then you write, huh? Delete all, huh? The petitioner has filed an additional affidavit in terms of the court has directed in terms of the order of this court, to which Mr. Roy, learned standing counsel, pressed for some time to response, some time to file response to the said additional affidavit. Huh? Therefore, pressed for listing of the matter after 4 weeks, 3 weeks,
Yes, ma'am.
2 weeks. Huh? Present list after 2 weeks. We'll see. Give the date after 2 weeks. Huh?
এই রেগুলেশন খন করবে এখন আমার রেগুলেশন
Yes. Hmm.
Also, it is ready.
Huh?
Both the written arguments are ready from both the sides.
we are filing.
Well, you just give it, that's all. Huh?
Therefore, just.
Full record, no? Their name, senior's name. Same, huh? You write here. MJ Ahmed, so and so, you check it from us. Hearing concluded, judgment reserved. You take that, huh? Hearing concluded, judgment reserved, huh? Same. Senior counsel, so and so, so and so. 22, 23, right?
There's a last note of 20 January 2026 starting observation made by the court.
20
January. Can you have a look at the last note?
Nayak. Produce the record. Where is Nayak?
My lord. We have filed our affidavit, my lord.
We know.
But in paragraph number 3, we have mentioned
Yeah.
they have to approach. My lord, in paragraph number,
What affidavit?
page number 36, my lord.
When did you file the affidavit? Additional affidavit,
My lord.
respondent number 6.
Yes, my lord. Additional, not additional, my lord. Affidavit.
Madam, after hearing, after considering all the affidavits, only we have,
My lord, we are ready. We are ready to pay, my lord.
pay.
They need to approach us with proper agreement and proper documents, my lord. They have not approached.
You are ready to pay.
Yes, my lord.
My lord, this
You approach.
my case is not regarding our payment, my lord, regarding our relationship.
My
We are
lord.
not ready to, even, my lord,
Sure, you don't want the payment.
but father,
Compens-
we are one the two prayers in this case, petition, my lord.
Huh?
We made a two prayer in this case, my lord. First, we want to get back our land.
Huh.
Second, my lord, whatever the land is due, then same may be released. to
Then
us.
you go there and approach them. What is your due? They are ready to
My
pay.
lord, for first.
Are you ready to pay?
My lord, we
Are you sure?
but they need to approach with proper agreement and document, my lord.
Your PWD.
My lord.
My lord, PWD annexure is at page 33 petition, my lord. Can you have a look?
Page?
33 annexure plus. Lordship give permission, I will read, my lord. This is contract.
Page?
33, read petition. This is a respondent number PWD to additional DC, my lord.
Huh?
Page 33, annexure 12.
Huh?
Yes, regarding the subject land under consensual. With reference to the above, I have the honor to inform you that the land measuring number so, which is under the process of so, has handed over to PWD on 16/12/2015, along with 29 number accommodation. In this regard, it is pertinent to state that nothing was mentioned by the BRTF regarding the owing of the land in question by some partners. Also, BRTF in the handing over note mentioned nowhere to relinquish the said land and hand over the partner if any appears to feature. The one set of document of handing over and taking over the said land is enclosed herewith for favor of your kind ready reference. So under the above circumstances, the claiming partner may approach to justify the claim with all specific relevant papers, including agreements, copies of the BRTF, so as to enable the undersigned to take appropriate action in this regard. And next, my lord, another application, my lord, and page 31, annexure 10. ADC wrote to the PWD. This is very important, my lord. With reference to the subjects episode above, I am to inform you that the land measuring number category the said land was vacated by the BRTF authority and handed over to the PWD and requested to relinquish their land and handed over the said land to the Patsasar. So you have requested to submit fee. So we, my lord, since it's a request from the ADC to the PWD to relinquish our land. So let the PWD to release our land and whatever was, we will release.
DC has.
See, on this basis, this PWD has returned back 7/12/2020.
7/12/19, then my lord, final letter is that is 7/12/2020. This is the last communication from the PWD.
See, they are ready to hand it back.
Yes. The lordship may dispose of the matter. We are ready to go to approach the authority.
So far as payment is concerned.
Payment and relinquishment of land.
Vacating the land.
Vacate of land. This is the.
Vacating the land, we are not the concerned authority, my lord. DC is the concerned authority. Because DC acquired the land, my lord. We have not, DC handed over to us.
That land is PWD. Admittedly, my lord.
No, my lord, we have, DC has handed over to us. So.
DC may be directed, you know, all these things to done.
To consider.
Yes.
And hand over.
Yes.
And if any rent is to be due, consider whatever. Yes. We'll go for shortcut.
Yes.
Mister, it's of no use. Because you want to settle the matter here, but then they are not, they are evading. Huh? Mister? PK Deka, learned counsel for the petitioner. Petitioners, right? And also heard
1, 7 and 8.
MSA Gyan, learned CJC for respondent number
1, 7 and 8.
1, 7 and 8.
I'm for PWD, my lord.
As well as Mr.
M. Das.
M. Das, standing counsel
PWD.
for Standing Council,
Let's
Public Works Department, huh? Or respondent number,
6.
Uh,
5
5
and 6, madam.
who is for 2 and 3?
Government,
Who is for the government? It is important. Deputy Commissioner is important.
ৰেকৰ্ড কৰি দিম
SR Bora,
এছাৰ পৰা নহয় এই চিনিয়ৰ এডভোকেট আছে তালুকদাৰ ছাৰ
Then my submission may be recorded, my lord.
What?
That they need to approach with proper paper documents and agreement, my lord.
The
already it's code of 5 paragraph 2, 3, 4 recorded the whole fact of the case.
where it is?
5124 order 5120.
By next filing this writ petition, the petitioners have prayed for a direction to the respondent authorities to handing it back the land measuring 2 biga 4 kata, huh? 2 biga 14 kata 12 chatak, huh?
12 lectures.
Letters, huh? Covered by diagram number 288 of 2/293 and patta number 115 of 1/117, situated of village Sideswar, part 2 in the district of
Asar below.
Kachar, Assam. The petitioners have also prayed for payment of outstanding rent, which alleged to have been accrued over the years in respect of the said land. List of how you have inherited. It's your land.
Our land below.
On what basis?
Liquid is our land.
Huh?
Liquid is our land below. What's it?
Your land or your parents' land?
My parents, my father's, the father died below, so we are the legal heirs of.
No, you are legal heirs, but then how it is come to you?
Ancestral property below, this is our legal, children of the father. Owners.
It is the, briefly put, huh? Come on, the petitioners, 5 in numbers, 5 petitioners
Yes,
claims to have,
6 below,
huh?
6 petitioners.
Then 6 in numbers claims to have inherited the land rights of their parents, huh?
Late father Motilal Kaur.
Of their father, your brothers.
You're all brothers sisters.
Okay. Let
Motilal Kaur.
Lieutenant Brar.
Motilal Kaur and below. Motilal Kaur.
Motilal
Or BHAR.
BHA Brar, huh? List of the case of the petitioner. No, sorry. And it is from so and so, huh? What I said? Who are brothers and sisters and the descendants of late Motilal Bora, BHAR. Huh? Claims that their parcels of land measuring 2 bigas, 14 katas, 12 lectures covered by doc number 288/290. You're listing something. You have seen this has been recorded properly. You're,
5174 order, can you have it?
I've seen it.
Paragraph 2, 3 and 4.
Covered by doc number 288/293 and patra number 115/117. Located at village Sideswar, part 2, comma. A Paranga Katigar, this is required to be
District Assam.
in the district of Kachar. Have been requisitioned by the Deputy Commissioner, Kachar on 26/11/1964. By requisition case number 8/L of 1964 to 1965. On account of the land required for maintaining supplies and services of essentials to the life of the community for establishment of a company, a company headquarter of BSF. Huh? BRO. They all recorded wrongly. You are saying that this has been
Yes, sir, said.
Except no BRO, sir. I'm paying for BRO, sir.
Yeah.
BRO under section 3 within bracket 1, Roman 1, capital Roman 1 of Assam Land Requisition and Acquisition Act 1964. Requisition acquisition shall be within bracket. Assam Land within bracket, Requisition and Acquisition bracket close Act 1964. তুমি এইটো বুজি নাপালে সুধিবি এনে ৰাইট যিখিনি থলাই দিলে মই এইটো লাগে After taking possession of the said land, same was handed over to the respondent authorities, namely respondent authorities BRO. BRTF or BRO?
Yeah.
That is in page number 83, madam. Can you come to page number? That is GREF.
Who told?
That is page number 83, madam.
Page 80.
Finally, madam, respondent number 7, madam, officer committing 1 and 2 RCC graph, madam. Cost title, madam. Respondent number 7, madam.
What is page 83?
It is, madam, that is the same version what we have already handed over to the DC, madam, basically. Madam, can you come to page?
I'm not asking about that.
Madam, can you come to respondent number 7, madam, page number 6, madam. Graph, madam. RCC graph, madam.
List of next para. The land acquisition proceedings appears to have been initiated by the Deputy Commissioner Kachar by the LA case number 6 of 2002 to 2002 for acquisition of the said land by issuance of notification under section 4 of the Land Acquisition Act 1894. Mr. The schedule of the said notification indicates that the petitioner's land were mentioned for acquisition list of the declaration under Section 6 of the Land Acquisition Act 1894 appears to have been issued on 21/06/2013. List of next period. It is the contention of the petitioner that during the period within which the land were under requisition from 1906-2024, the petitioner had received the last requisition rent only on 05/08/2005, and the memo disbursing requisition rent did not also disclose the period. Subsequent to 05/08/2005, no rent was paid to the, no requisition rent was paid to the, no, not subsequent. Since 05/08/2005, and no, after 05/08/2005, the petitioner was not paid any requisition rent. List of the requisition plan no. It is further contains that there was no the land of the petitioner was not acquired by following any valid process of acquisition, as the respondents have not brought anything on record as regards the culmination of land acquisition process. Under the relevant provision of law. List of the petitioner further contends that although an amount of rupees 6,36,665 have been deposited by the respondent authorities and the same before the Deputy Commissioner Kacher, no payment has been made to the petitioner. List of The petitioner contains that since the land has been used by the utilized by the respondent authorities since 1964 without there being any without there being any proper without there being any acquisition, valid acquisition proceedings and payment of compensation and requisition rent. And now the Union of India, no, the respondent BRO has handed over the land to the Public Works Department of the state. Comma.
Apply to.
The petitioners are entitled to take back the land. Therefore, the respondent authorities may be directed to hand over back the land to the petitioner as no proper acquisition proceedings nor requisition rent having been made and paid to the petitioner. This stuff. The who has filed the affidavit? No, Union of India respondent number? Respondent 6, 7. That is BRO. GREF. Come on. Has filed an affidavit which indicates that the Deputy Commissioner Kachar has estimated the amount of compensation for acquisition of the said land of the petitioner by LA case number 6/2002-2003 for an amount of rupees 6,36,665. The which was deposited with the Deputy Commissioner Kachar on 08/04/2008. List of the stand of the respondent PWD reflects that the land belonging to the petitioners were handed over later on by the Deputy Commissioner Kachar to the PWD for the purpose of construction of a road with the assistance of 112 RCC within bracket GREF on 16/12/2014. Next para. Mr. Deka, right? Ardeka. PK Deka, land counsel for the petition submits that there is no dispute as regards to the ownership of the land in question, being as the petitioners are the patadars who have inherited from their late father, huh? From the late father. List of. It is equally. No, there is also not in dispute that that no valid acquisition proceedings was undertaken by the respondent authorities for acquiring the land of the petitioner. List of it is only at the initial stage for some period requisition land was paid to the father of the petitioner, not to you, father of the petitioner, and the land was under the continuous possession of the respondents since 1964, and finally handed over to the respondent PWD, which is still under the possession of the PWD, respondent PWD, without there being any further acquisition or payment of compensation as per the law. Please. Next paragraph. MS G. Gyan, London CJC, submits that an acquisition proceedings was done by the competent authority for acquisition of the land in question, which was initially handed over to the respondent respondent GREF, and the respondent and the requisition rent were paid to the patadar. Please stop. After the acquisition, an amount of rupees 6 lakh something, huh?
36,660
was directed to be paid to the landowner, to which by the Deputy Commissioner Kamakatsa, to which the respondent GRF has deposited the same with the Deputy Commissioner. This stuff. Next para. No, please stop. Thereafter, the respondent GRF has handed over the land to the concerned authorities. Therefore, the respondent GRF has no role to play as per the claim, so far as the claim of the petitioner in respect to claiming back the land, claiming of the land to hand over it back to them, or any claim for payment of either compensation or requisition rent. Please stop. Next para. MS MDAS, Learned Standing Council, PWD. Without adverting to the nitty-gritties and the stance, and without adverting to the stand taken by the state respondents, submits that the land, no doubt, is with the Public Works Department at present. However, what is that your letter claim? which you have shown?
33 and answer 12.
33. This is their letter only,
Yes, my lord.
page 33. Huh?
PWD.
Huh? What I said, no doubt, huh? At present, currently with the, is under the position of the PWD, comma, the petitioner may approach the concerned authorities claiming may approach the concerned authorities for redressal of their grievances with a proper justification to their claim with all the specific or with all relevant papers, including agreement copies with the BRTF, so that the grievance, if any, so that so that in the event the petitioner is entitled to claim back the land and claim back the land as well as for and for payment of any requisition rent could be addressed in accordance with the law. Please stop. Huh? Next paragraph. Having no. I have considered the submissions of learned counsel for the parties and also peruse the materials available on the court. Next paragraph. Records reveals that. No, before that, the petitioner appears to be the Patadars by virtue of being the descendant of late Motilal Bor, who has allowed the GREF to occupy the land on payment of requisition rent, which in fact was paid at a relevant point of time. Right, Mr. The Deputy Commissioner Katsar has initiated an acquisition proceedings subsequently for acquisition of the land in question, for which an amount of compensation, amount of rupees 6 lakhs, so and so, same 6 lakhs, 6,000 something, 66,000 something, right? Was assessed. The amount of compensation assessed appears to have been deposited with the Deputy Commissioner Katsar. However, same has not been disbursed to the petitioners, either to the late father of the petitioner or to the petitioner. It has not been disbursed with. I don't know where it has gone. This stuff. The next para. Respondent GRF had relinquished the land in question and handed over the same to the respondent PWD through the Deputy Commissioner. Mr. The Deputy Commissioner, the Addition Deputy Commissioner by letter dated 27, by communication dated 27/02/2019 to the executive engineer PWD within bracket NH division bracket close Silchar. Had informed that the land measuring 5 bigger. Okay.
May I please, your lordship, in the lordship, may let this matter be for personal for the time being, lordship, the conducting council is coming.
No, it's enough. Enough is enough. And the land, including the land of the, as regards the land, at village Siddheshwar part 2, including the land of the petitioner, right?
Yes, Lord.
Was under the inform, right? Right, said I've said right in the inform, inform that the parcels of land, including the land of the petitioners, situated, located at village Siddheshwar part 1 in the district of Kachar was under the possession of 112 RCC within bracket GREF bracket close within bracket BRTF bracket close. Please step. The same land was vacated by the BRTF authority and handed over to the PWD. There were requested to relinquish and hand over the same to the patadars. In this regard, in that regard, the additional deputy commissioner, Kachar, has sought for reviews from the executive engineer, PWD, NH division, Silchar. The in response to the said letter, the executive engineer, PWD, NH division, Silchar, had admitted that the parcels of land, including the land of the petitioner, was handed over to the PWD NS Division Silchar by the BRTF on 16/12/2015, along with 29 numbers of accommodations. However, informed that informed that there's nothing on record. They informed that nothing has been mentioned by the BRTF authority regarding the ownership of the land in question by any patadar. And the handing over note doesn't mention of relinquishment of the said land to the patadar. Listen. In such situation, it has been informed that the claimant patadar, if any, may approach the concerned authorities with a justification of their claim with all relevant papers, including agreement, if any, with the BRTF, so that the matter can be redressed by the competent authority. List of next para. Upon consideration of the materials available on record, comma, it is seen that the petitioners are the patterners of the land in question, particularly of a land measuring, what it's called? Measuring
2 biga 14 kata.
2 biga 14 kata, then 12 leches located at Sidwesher village, Sidwesher part 2 village in the district of Kachar. List of the father of the petitioner appears to have received the requisition rent at the for some time. However, no further requisition rent appears to have been paid to the petitioner on the demise of the their late father. List of the deputy commissioner initiated a land acquisition proceeding subsequently with an compensation amount of rupees 8 lakhs something, 66 lakhs, which is to be paid to the patterners, public landowners. And the same was deposited with the Deputy Commissioner Kachar by the BRTF, respondent BRTF. However, nothing is brought on record as regards the disbursement, public payment of the said compensation to any patterners. List of the it is also not disputed that the respondent BRTF, who initially under the occupation of the land in question, has handed over the same to the PWD, state, the respondent PWD, which is currently under the possession of the said land. List of possession of the land without there being any proper acquisition and payment of any rent to the patterners. List of next para. Next para. It is worth mentioning that considering the issue involved in this proceedings, ample opportunities were given to the state respondents to produce the records as regards the acquisition and requisition of the land in question. However, the state, the learned counsel for the state respondents has failed to produce any documents won't rely. What is this?
Lordship, in this regard, Lordship, in fact, a committee was formed to trace out that file particular, but it is not traceable. That instruction.
I have recorded where,
I pray can it be
Under such
part of
situation,
the record, Lordship?
this court, no, this court has no option but to proceed with the matter to serve the interest of the parties. Please, next para. Now, having considered that the petitioners appears to be the author of the land in question and the and their land having been under the occupation and possession of the respondent authority, respondents, whether there be any valid acquisition proceedings or payment of any compensation or requisition rent, I deem it appropriate to no, I am of the considered view that the petitioners are entitled to be handed back the said land to them and to pay the compensation and to pay requisition rent in accordance with the law. List of. However, considering that at one point of time, the father of the petitioner was paid with the requisition rent and the Deputy Commissioner Kachar has initiated proceedings and assessed a compensation of compensation amount of rupees 8 lakhs so and so, which has been deposited with the Deputy Commissioner Kachar, I deem it appropriate to direct that that amount of compensation as assessed and deposited with the district Deputy Commissioner Kachar be paid to the petitioner as a requisition land in view of the fact that the land of the petitioner in view of the fact that the petitioner was deprived of the land without following the due process, without any authority of the law, much less following the minimum procedure for acquisition of the land in accordance with the law. Please stop, huh? For complete settlement of the issue, and in view of the lackadaisical attitude of the state respondent in the present proceedings, and considering the interest of the parties, it is further directed that the petitioner to submit to approach the respondent authorities, particularly Deputy Commissioner. This Deputy Commissioner Kachar, respondent number 3, raising their grievance as regards the raising their grievance with regard to payment of requisition rent within a period of 20 days from today. Huh?
The 20
Please
days
stop.
lordship, the election,
Requisition. We're not concerned.
election period lordship.
We're not concerned within 20 days from today. They will approach within 20 days.
Or they will approach. Oh, then.
Sir, they will
Lordship,
approach. With regard to requisition rent, requisition of rent, nothing else. The Deputy Commissioner shall consider and decide the same within 2 months from the date of receipt of the application that would be filed by the petitioners. Please stop. As regards the handing over, as regards the claim of handing over of the land, since it is not disputed as regards the ownership of the petitioner being a patadar, same shall be handed over within a period of 2 months, within a minimum of 3 months thereafter, and within a minimum of 3 months, if the land is not required for public purpose, and if it is required for public purpose, the authorities is at liberty to acquire the land in accordance with the law.
Lordship, I pray that instruction may be kept part of the record, lordship.
Enough.
Because we have tried, lordship, not, it is.
If I record this, I may have to pass remarks, adverse remarks. See, we have given you enough time.
Yes.
We took up the matter. It's been 6 or 7 times.
Yes, Lord.
Ample opportunities.
Yep.
And when at one point of time, this court was inclined to, release from the further.
Lordship, I am not about.
We're
this
not
order,
concerned about you or him.
But I am concerned about.
We're
the record.
concerned about the state respondents.
Yes, because lordship has.
Whoever appears, we are not, not personal.
Yes, what lordship that.
Anyway, thank you. Record. Madam, you just give the name.
Yes, sir, respond number 3.
On behalf of respondent number 6 and 7, it should be 7 and 8, my lord.
It's okay, you are BRT.
Yes.
Yes.
Item 25. Lord, it's part, but then looking at the time to be.
Yes.
Yes, Lordship, we have received instruction, but as per our instruction, we have already stated our grounds on affidavit.
In the affidavit.
Yes.
Heard Mr. B. Pathak, learned counsel for the petitioner, and also heard Mr. M.S.
S. Borua.
S. Barua, learned CGC. Hearing concluded, judgment reserved.
Hearing not.
Hearing concluded, judgment reserved. I have heard you. You have no further instruction.
No.
Except the same instruction which is in an affidavit.
As per our instruction, Lordship,
Ha.
our annexer J
Ha.
of our affidavit,
Ha.
that is Assam Rifles Rule
Ha.
2010.
Ha.
It states that basic combatants training is compulsory to appoint keep for the promotion, Lordship. But that basic combatization course has not been done by the petitioner. Therefore, he was not eligible for promotion, Lordship.
Yes, what is there?
In the last.
Let us see there. What is there? Your affidavit? Page?
Page 44, paragraph 8.
Of your affidavit?
Yes, Lordship.
Page 44.
May I read?
Yes.
with regard to the statement. Paragraph 8. With regard to the statement made in paragraph 8 of the writ petition, the answering deponent begs to state that the petitioner was enrolled as assistant commandant dental surgeon on 29 November 2010. The petitioner could only be promoted to the rank of deputy commandant on 29 November 2014 after completion of 4 years of service in the present grade and fulfilling all other qualitative requirements, and not on 20 May 2014 as mentioned by the petitioner in the writ petition. The petitioner was considered for further promotion to the rank of deputy commandant during the DPC year 2015 to 16. However, on the said DPC, a clarification was sought by the MHA that whether the officers recommended for promotion to the rank deputy commandant senior dental surgeon have completed basic competization training or not in terms of RR 2010. So headquarter DGAR had clarified that assistant commandant dental surgeon Suman had not attended the basic competization training course due to child care leave, and MHA was informed about the same accordingly. MHA has approved the promotion of the 12 assistant commandant who were considered in DPC for the year 2015-16 except assistant commandant Suman, as she had not cleared MOBC due to child care leave. Basic competization training, that is. The answering deponent also begs to state that the basic military training conducted at Assam Rifles Training Center School as referred by the petitioner is conducted immediately after recruitment of Assam medical officers in order to familiarize the newly recruited Assam Rifles medical officers to the basic military life and functioning of rifles, Assam Rifles. This course is not the mandatory course as per RR 2010 for promotion from assistant commandant to deputy commandant, which is he has done immediately after joining the Assam Rifles. After completion of 4 years, he was required to complete the basic training, but competized training, but he has not done because of child care leave. And when he complete the competition course, after that he get the recruitment promotion. Petitioner is only trying to mislead the so-and-so.
Misleading is a misleading. The last order.
The officer has to undergo medical officer basic MOBC, huh? There is no record to show the MOBC is equivalent to basic competence as required under the rules. In view of MS so and so, this is the one that you have already explained.
Yes, Lordship. MOBC, on last occasion, Honorable Court directed to clarify that whether the MOBC and basic competition course
is equivalent
or not. Whether it is equivalent or not, it is not required because he does not complete the competition course, Lordship. Competition course is necessary as per the rule. Annexure J, page number 69.
We are talking about the rule under 309. The 309.
Medical officer basic course, that is MOBC, right?
Basic competized course.
Huh?
Here, as per the rule, basic competization course is
MOBC.
Yes, medical officer's basic competization course.
No. Medical officer basic course. So what is the?
As per page 66.
What is whether this is a basic competization course?
Yes.
Competization course?
Yes, is
from where? From which rule?
As page 66. Assam Rifles Rules 2010.
66.
Page 66. Paragraph.
Where it is? From amongst dental surgery assistant commandant on completion of 4 years of service in grade and being in medical category safe 1, and on completion of basic competization training.
Which is not done.
What is basic competization training?
That training is conducted with arms, Lord.
Training on arms and comparing of arms. This is the basic
competization course.
Because that training has to come before you enter the service. You cannot enter the forces without knowing A to Z of the arms and other things.
And duration of
this is my lord, that are in there.
And due
So according to this medical officer basic course,
basic
MOBC, is a basic combined combatization training.
he does not, he complete this course only after on 2024 2016, and after that 15/6 2017 he was promoted.
Huh?
After completion of this course, the basic combatization course, he had promoted to the next rank.
When she was promoted?
On
Huh?
2nd June.
And
Yes,
she has completed MOBC?
That course is called MOBC.
When she has completed?
Yes, 24 2016.
Ah.
That is this course is 12 weeks course.
No, that's why I say rule doesn't indicate that what is this?
But indicate
MOBC is equivalent to is a basic combatization
that
training.
is not mentioned, but combatization.
That's why we want.
No, let's say that, but combatization course is required.
See, once it says in the grade and being in medical category safe one, hey?
Yes.
And on completion of basic
Competition course.
What is the basic combatization? Combatization
yes,
course is what?
That is not completed.
What it is?
It is a training course with arms, Lordship.
Which one?
Basic combatization course.
No, so what is that? Then you said MOBC?
MOBC, if both are not equivalent, then he was not eligible for the promotion till now. Because
Madam, that's why we want you to file an additional affidavit clarifying all this. You said she has not undergone medical officer basic course, MOBC.
Yes, we have said that he has completed that MOBC course on.
See, whether this is a basic combatization course.
Lordship.
It doesn't sound also. See, medical officer basic course is what? Medical officer had to have that the guns and bullets.
No, that is familiar to person to Assam Rifles. Lordship.
What is
that
this?
Basic
Medical officer basic course is what? MOBC. You said she has not done this. She has not completed MOBC.
Therefore,
right?
Then
Which you consider is a basic combatization training.
Training.
So what is basic combatization? Is it consist of, is it this MOBC is a basic this combatization training?
A medical officer's basic combatization training.
What
Basic
does it mean?
combatization
No,
course.
no. Where it is?
Medical officer basic course
Basic course.
of competence.
But as per rules, combatization course is required.
Where?
That is not completed.
Where it is? As per rule, where it is?
Yeah, this on page 66.
Madam, it says basic combatization training. What is this? Is it MOBC?
Basic combatization training is a course.
Is what?
For medical officers, it is called medical officers basic combatization course.
No, it
Training.
doesn't say. What is MOBC? Tell me what is MOBC?
Medical officers basic course.
Huh?
That is but he does that combatization course not completed. Then he is not eligible for promotion on 2016 also.
As per which rule?
In 2010 rule. As because
What does it say that you have to complete MOBC?
he complete MOBC. If MOBC is not equivalent to the basic combatization course, then he is not eligible for promotion.
From where will we get it? That's the reason we ask you to file an additional affidavit.
Yes, yes. Then I will explain it on my through my affidavit. I can explain it.
No, this is my third time. It's enough.
Kindly one.
You file an appeal. Same order.
From 2011,
Huh?
this same argument was placed, but you have clearly indicated on
No.
order of.
No, he's relying on, he's trying to,
Lordship, may I please one thing, Lordship?
he's trying to have a proof reading on her affidavit.
No, Lordship, one thing is.
Madam, that the other day we have heard you.
Yes, Lordship,
I may say that perhaps.
One more hearing is required, Lordship.
Why?
Clarify, No, Lordship, here one.
You are trying to say the MOBC is a basic combatization training,
Yes, Lordship.
which you are
He-
not which you are not convinced,
Then he is.
which I am not convinced.
One thing.
For
Lordship,
that, I have given you ample opportunity.
One-
3 times I have granted.
One thing, Lordship,
Ha.
one thing, only.
Thank you.
One thing, Lordship. If he is not complete the basic course as per the rule, then he is not eligible for promotion on 2016 also.
Madam, what is the basic eligibility course?
That is in
What is basic course?
that is in annexer as per the Assam Rifles Rule 2010.
It
Basic-
doesn't talk about MOBC.
Not talk about MOBC. Therefore, his promotion, which is he is obtained in 2016, that is illegal.
We'll see. Huh? Hard, Mr. NNB Chaudhary. Not hard. Due to paucity of time, matter could not be taken up. As prayed for, let this matter be listed after Bihu. After Bihu. What is this? What do you want here?
24-26, I have difficulties any day, Lordship.
Yes, I know. Mr. Gogoi will say. He will not do anything before this thing, Bihu. So make it after. 3rd is holiday. 3rd April holiday. Six. But I'm sorry, yeah. We'll consider, we'll see. I'll consider your submission.
Kindly see.
CAB.
One thing observe, Lordship, one thing can kindly observe, the promotion is granted as per rule Assam Rifles Rule 2010.
Obviously, we'll consider on that basis only.
On the basis of that, basic combatization course is required, which is not completed. Obliged.